Assalamu alaikum, Sheikh Hussain. Assalamu alaikum, Brother Shakir.
السلام ورحمة الله وبركاته.
How are you, sir?
السلام ورحمة الله وبركاته.
الحمد لله. How are you?
Alhamdulillah, everything is good, sir. Let's wait for a couple of minutes before we start. People are joining now.
حياكم الله فضيلة الشيخ.
بكم شيخ شاكر، كيف
بارك الله فيكم.
حالكم؟
الحمد لله الحمد لله، بارك الله فيكم.
الله يسلمكم.
بسم الله الرحمن الرحيم. الحمد لله رب العالمين، والصلاة والسلام على أشرف الأنبياء والمرسلين نبينا محمد وعلى آله وصحبه أجمعين. أما بعد, we welcome everyone to today's hearing sessions of AAOIFI Shariah Standards number 62, Sukuk, that will be chaired by respected Sheikh Hussein Kirani and presence of Sheikh Assam Ishaq. And in the beginning, we have a keynote address by the General Secretary of AAOIFI, Mr. Umar Mustafa Ansari. As you know, Sharia standards are of great importance in the Islamic financial industry. It is compulsory to apply them in many countries, such as the UAE, Bahrain, and up to 20 other countries. Each Sharia standard passes through at least 10 stages, from assigning a researcher to prepare a study and a draft, and then discussing in one of the committees affiliated with the Sharia board. One of the most important of these stages is presenting the draft to public hearing sessions in several countries and via the internet to receive comments from scholars, lawyers, and others related to the industry. So today we are in a public hearing for a draft of an important standards, as I mentioned, draft number 62 of Sukuk. I would like to inform you that our Sharia board member decided that public hearing sessions are limited to receiving observations, not discussing them. Our rule in the General Secretariat is to listen to the observations and record them for presentation to the Sharia board, noting that the Sharia board discusses all observations with great care and often changes some items based on these observations. The item will not be read in the sessions as usual due to the length of the draft, but rather a number of them will be determined successfully, and the door will be open to receive comments on them. Now, I ask Mr. Umar Mustafa Ansari, Secretary General, to give a keynote speak.
Thank you, brother Dr. Abdurrahman. أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقهوا قولي. Ladies and gentlemen, respected scholars, my dear colleagues, my friends, Assalamu alaikum wa rahmatullahi wa barakatuh, and very good morning and good afternoon, depending on the parts of the world from where you are joining. It is honestly one of the greatest pleasures to be here with you. We can see a very large number of registrations, mashallah, 600 or so registrations, while the attendees at this moment are not that large in number. And one of the reasons that we know is that we have already conducted public hearings in multiple Islamic finance hubs around the globe: Malaysia, Saudi Arabia, UAE, Pakistan. These are the public hearings that were already very well attended. I can understand that this was equally important, that those countries who are not covered within the physical public hearing must be given an opportunity to join us online. This public hearing, as we communicated earlier, will be held in English language. The approach towards the public hearing has been already defined by Brother Dr. Abdurrahman. I would like to just emphasize on a couple of points, and particularly I would like to update the industry with regard to some of the things that have already happened on this standard. First, it is very important to understand that we are now towards the last stages of the standards finalization, while this has gone through numerous activities in between. While Brother Abdurrahman mentioned about the normal steps that we take, but I would like to mention that for this standard in particular, additional steps were also taken, including roundtables and workshops during the development stage and interconnection with different industry and stakeholder segments, even during the process of development and even during the process of initial preliminary study and research that was conducted. I would like to particularly emphasize that while AOFI is here to support the industry in all possible means, we still have some core principles which are leading our way of developing the standards. While we acknowledge a lot of industry concerns, at the same time, we have to address those concerns in line with what is the merit of the matter according to Sharia principles and rules. This standard in particular has got a lot of attention from across the globe. We have received numerous comments during the public hearings. We have received written comments individually from experts, collectively from some financial institutions, as well as multiple financial institutions and other stakeholders providing comments together. We highly appreciate each and every comment that we have received. And we would like to assure you that our Sharia board has already started the process of reviewing these on a priority basis. The comments received till now have already been presented to the Sharia board. We are going to conduct this public hearing, and in 10 days' time, we will be holding another public hearing. Probably that will be the last public hearing that will be conducted in Bahrain physically. We may, at this point of time, we are discussing, and Secretariat has proposed to the Sharia board that we may conduct a specific roundtable or workshop on some of the key pertinent issues with the stakeholders who have raised those issues. This is just to ensure that the standard setting process is transparent, it is robust, it is taking into consideration the concerns, issues, challenges that are coming and to the market, that are being faced by the market, and those concerns as they are presented to the Honorable Mashayikh and the Sharia board. We ensure that each and every comment is taken on merit, and that is what we are going to do today, inshallah, as well. As Brother Abdurrahman already mentioned, that we do not want to have general discussion, but for sure, we want you to have all the opportunity of being heard. Normally in the online public hearings, our first approach is that we allow the questions and comments in the Q&A tab, and we try to address all of those. Just to mention that if time permits, we'll allow some of you who insist to use the microphone and switch on the video to talk personally. This will be subject to time availability in line with all our public hearing practice, public hearings. But the main source of or main way of getting the comments would be from the Q&A tab. And please note, it should not be through the chat window. It should be through the Q&A tab. Now, a little bit about some of the concerns that we are having. I would like to share one slide, which I normally share in a lot of different presentations. And this would be my preamble for today's discussion. At AOFI, we believe that Islamic finance is different from conventional finance because it would not have been needed and hence not existed if it was not different. I re-emphasize, it would not have been needed and not existed if it was not different. Because it addresses the financial needs of those who may not get those addressed by the conventional finance. And because it is based on foundations different from the conventional finance. I think we all generally understand that part. And last but not the least, and maybe this is the crux, if it is not different, then it's not Islamic finance. I'm sorry. This is something that I normally present and not in public hearings. mostly in the training sessions. And we justify that whatever standards we develop on the Sharia, accounting, auditing, governance, and ethics side, they are there to address the specific needs of Islamic finance, which are fundamentally different from conventional finance. And this is where I would like to request all of you to have this thing in mind while we go through this discussion on this standard and have noting on comments on this one. So on a lighter note, in Pakistan, there was a bank called Muslim Commercial Bank that later they changed their name to MCB. It was Muslim Commercial Bank, established maybe 70, 80 years back. The point that I want to present to you is simple. Now, although they have a MCB Islamic banking subsidiary, and purpose is not to criticize one bank in particular, I'm just talking about one mentality. There is a mentality at times in the capitalist, in the businessman. You know, in different parts of the world, you will find Islamic honey. Okay, honey is always Islamic. Honey is always Sharia compliant. But putting Islamic honey wants to use the benefit of people's faith associated with the word Islamic. The same approach applies to that connotation of Muslim Commercial Bank. We are doing a pure conventional banking, pure interest-free banking, something that is haram, that is, God forbid, war with Allah Almighty and His Messenger. But what we are doing is that we are using the benefit of faith of people to sell our product. There is no harm in using the word halal or Islamic, for sure. You can have all the rights in the world to use that to attract a particular view of people. But you know, when it says as vegetarian or vegan, and you don't do it, you can be sued in all the developed markets. AAOIFI is doing its own humble effort to make sure that what is called Islamic, what is called Sharia compliant, is genuinely Sharia compliant. We do not want to open the market in a way that what is Islamic and what is not Islamic creates confusion in the market. It has to be clarified for the markets. It is very important for having a sustainable, resilient, robust financial system based on Sharia to have appropriate principles of Sharia in place, appropriate principles of financial reporting in place to make sure that what is Sharia compliant is presented, recorded, and reported in line with Sharia. We need to have appropriate systems of governance and control to make sure that what is written in the rules is actually implemented on the ground. We need to have audit and Sharia audit mechanism to have a double check on the implementation. And we need to have ethics as the soul and the essence of Islamic finance. That is what we are doing to support the industry in our humble way. Just to mention that this project, when we started the project on Sukuk, we also initiated the standards on accounting and governance side. The governance standard GS12 was issued some time back. On accounting, 3 standards were planned, out of which 2 standards were finalized. Accounting for the asset side, that is investment in shares, Sukuk, and similar securities. That was finalized. Phase 33, Phase 34 on the financial reporting for the Sukuk holders. That was finalized. And the standard number Phase 29, which was intended for the financial reporting for the originator was kept on hold, that it will be finalized alongside this Sharia standard because both have correlation to each other. We intend that as soon as this standard moves towards finalization, we also finalize PAS 29 as well. Now, coming to one last thing before we go to the discussion on the standard. When we talk about standardization, there is one very important connotation that need to be understood, that is standardization include two areas. One is harmonization, that you need to bring harmony across the board, which means that if I go to Malaysia, if I go to Pakistan, if I go to Bahrain, if I go to Saudi Arabia, and I want to do banking with any of the Islamic banks or want to have a takaful product with any of the takaful entities, I should be confident that each one of them is selling me a comparable product. Those products are according to the same core principles, and every time it is not necessary that I go in detail of every contract, every nitty-gritty of the contract, particularly considering that mostly the customers are not that much understanding the details about this thing. So they need to be given that confidence that this is according to a harmonized set within jurisdiction and across the globe. That is the harmony part. But standardization does not end at harmony. Standardization also has the connotation of best practices. What are the best practices? So when we say that this is of something of standard, so I normally give this example that if you purchase different sets of plugs and sockets, the harmony part is that those plugs and sockets should fit into each other. So if I have my mobile charger, that mobile charger should be able to fit in different sockets. However, the second part is that those plugs and sockets should not be causing damage to my mobile. Those should not be causing short circuits. Here comes the best practices and the quality of the product. So when we talk about standardization, we cannot ignore the connotation of quality of the product. And when you talk about quality of the product, it comes through a very, very long process of discussion on matters of fiqh and their contemporary application. And here we have a significant challenge that some of the people say, okay, this was approved by my Sharia board. Why AAOIFI Sharia board is not approving it? The answer is, with all due respect, we have all the respect for your individual Sharia board and the scholars sitting on your individual Sharia board. And it is quite possible that some of them are sitting on AAOIFI Sharia board as well. But you need to understand that at the level of a global entity that develops the standards for a global basis, they need to come up with a consensus that can be achieved. So while I know that some of our individual scholars may have different views, according to their own personal ijtihad, their own personal interpretation of Sharia, or according to the relevant school of thought that they follow. But you need to set up a standard that is acceptable for everybody. So let me give you a very common example. In Pakistan, according to local school of thought, currency salam is allowed subject to certain conditions. But do you feel that this currency salam product may become, and we have all the respect for those scholars who approve it because they have their own justification for that according to fiqh. But at the same time, do you think that AAOIFI can incorporate that thing in AAOIFI Sharia standard while it is not accepted by majority of scholars across the globe? So we need to understand that the Sharia board's responsibility is to find consensus. which means that the product that is eventually approved according to AAOIFI Sharia standard is acceptable on a consensus basis, after taking into consideration the views of different mazahib, different schools of thought, and different contemporary application issues. So while I do not want to go in this detail, but I felt that this is very important and fundamental that to understand that when AAOIFI develops a Sharia standard, the Sharia board has this huge responsibility on their shoulders to ensure that a consensus can be reached on that one. And they cannot just go on individual views. So while we respect each and every individual view, at the same time, it is fundamentally important that the market is based on harmonization and best practices. That is what this standard is all about. I know that when we go through this discussion, we'll be receiving lot of comments. And I can tell you, while we have received lot of negative comments, people feeling that AAOIFI Sharia board doesn't listen to us and all that. On the other hand, I can tell you, I have learned from scholars, some of the genuine experts, scholars and some experts, that this is probably the best ever standard developed by AAOIFI. So yes, we know where there will be difference of opinion, and now we move towards discussion on the standard itself, and we hope that this standard discussion will be very fruitful. So, Brother Abdurrahman, I think we should move on, and I think there were a couple of points. There is one comment from Brother Sadaqat that I can see in the Q&A tab. Brother Sadaqat mentions that, can you also share a slide comparing some of the major differences between bonds and sukuk in practice? Brother Sadaqat, actually, based on your question, I have one slide that will identify the fundamental differences between Islamic finance and conventional, which addresses that difference that you are talking about. So I'll very quickly take all of you through that one very quickly. This if Brother Sadaqat, if you see, if we identify the core principles, so no predetermined returns on loan. The first column is prohibition of riba, prohibition of gharar, prohibition of masir and qimar, equitable distribution of risk and reward, time value of economic resources, and no time value of money, and integration of moral and ethical values. So if you go to the first column, no predetermined returns on loan, no debt rescheduling and credit rollovers, no additional charges on late payment, no sale of debts and receivables. Prohibition of gharar, avoidance of excessive unnecessary risk, a prohibition of exploiting ignorance and jahl, no short selling forwards and futures, prohibition of messer part, prohibition of all forms of gambling, prohibition of speculative transactions. Then we go to equitable distribution of risk and reward. Capital alone has no right of earning. This is one of the fundamentals where you will find the difference between Sharia compliant bonds, such as Sukuk, versus the conventional bonds, that capital alone has no right of earning and no concept of risk-free rate of return. You have to take risk. And capital alone is not eligible to earn till the time it is not put into a permissible activity. The next column, time value of economic resources and no time value of money. This is also fundamental. You need to understand money cannot be traded for profit or against time and rented. Mostly asset-backed transactions, and time value of assets, goods, services, and entrepreneurship is what we charge return on. So if Sukuk is in a form of pure money, you cannot have a return on that unless it go through a legitimate Sharia compliant transaction based on sale, trading, entrepreneurship, or services. Time value of assets, goods, and services and entrepreneurship is what on which you can charge income. And integration of moral and ethics values, no financing of unethical goods, alcohol, social responsibility, and social finance to be integrated, and ethical values to be integrated. So this is a very quick answer to your question, and I believe that we can all keep it in mind while we go through this whole discussion. With that, I just stop here, and I thank all of you for patient listening, and I think we now need to move ahead towards the discussion on the standard. Brother Abdurrahman, we have two versions of the document on the online. Always PowerPoint with the bigger screen size is workable, but which one you would like me to use?
So
For
I
me?
asked Sister Noof, she will
Okay.
present like the draft. We will go one by one.
Because
The same.
draft on a screen becomes very small, so that is why we normally use the PowerPoint version, which makes the things like easy to read for the participants. Because if we only use the PDF version, it will not be able. This is exactly the same document, but it shows it more clearly.
Yeah. Okay, we can use this
Yeah,
one.
so that is normally because online particularly this becomes more like easy to read for everybody and we can show it easily. So I think let me keep the control and let me start at my end. Sheikh Hussain sir, with your permission, we can start. But before that, if you want to say something, particularly like on this standard, as your role in development of this has been very crucial, even as chairman of the working group. So if you want to say something, it will be highly appreciated, sir. Please.
Thank you, Brother Umar. Assalamu alaikum. Bismillah ar-Rahman ar-Rahim. Wa ashrafu as-salatu wa atammu taslim ala khayri khalqillahi ajma'in. Sayyidina Muhammad wa ala alihi wa sahbihi ajma'in. First of all, I would like to thank you all for attending this hearing session, the online hearing session. And also I want to thank as well Brother Dr. Abdurrahman for his explanation about the approach of the session, and Brother Umar for his introduction. I don't have any specific thing to add, but about the difference between the Sukuk and the bonds, I think we will see soon, the article or paragraph number 3 is of the standard is answering this question. It tells us what are the differences between the Sukuk and the bonds. And inshallah, we'll come to this paragraph during the discussion. Thank you.
Thank you very much, sir. I think there are a couple of more comments. These comments are more like, okay, there is comment from Brother Sufyan Desan, put it on presentation mode. We'll do that. And for going forward, and Brother Yasin Muhammad, forward presentation. Okay, at that time we were showing only one slide. So now we will be taking the main presentation and we'll moving it forward. I can see some comments on the chat window, but just a request, as a request, that if anybody has comment, please put them in the Q&A tab. There is a point from Brother Mufti in the chat window. Please appreciate if the option of online will also be available roundtable meeting if conveniently possible. Yes, if time permits, we will allow some of you to allow you to explain your points. That is that is given, inshallah, subject to time availability. So with that, sir, we'll share the presentation and we move ahead. So this is exactly the same as exposure draft that you have. Exposure draft has been issued in Arabic originally, and English is the official translation, unofficial translation at this moment. Official translation will be issued once the standard is finalized. This presentation reflects only the English one, but because the primary language for today's discussion is English. But if anybody has a comment on Arabic, we can share it at the same time. So maybe I request Sister Nofi that you keep that Arabic version ready as well. So if we receive any comment specifically either related to translation or on the Arabic language, it can be handled.
So, Jazakallah khair, Brother Umar. Now, after your permission, we ask Dr. Usaid to chair the session.
Sure.
You can go ahead. Brother Umar, he has the presentation, and he can control the discussion, inshallah.
Okay.
Okay. So do we have any comments on the preamble? Okay. We come to the scope. And is there any comment on the scope? The standard deals with various types of sukuk, does not deal with shares of companies, certificates of investment, deposits, units of funds, and investment portfolios. Sheikh Hussain, I personally, received a comment earlier on this part, I remember, and I personally have a comment on this one as well, if it can be because what is not included, like particularly certificates of investment deposit, unit of fund, and investment portfolios, a little bit of clarification might be needed in these things because some of the restricted investment funds, some of the unit funds may have characteristics. So, for example, in accounting and governance, we have distinguished, for example, that we say that if it forms a proper legal entity, corporate entity, then it goes out of the scope of this. So some clarification might be needed because I received this comment myself, and then I noted that some more clarification is here needed. So this is just a comment that we can keep a note, and based on the comment that I personally received and a little bit observation that we have at our end as well.
Okay.
Any other person has a comment on this one?
Brother Umar is not moving. His slides are not moving, if you can.
Okay, let's just first take comments quickly. We have a comment from Megat Hassan. Will you be able to share the slides as some of the content are not strictly speaking based on the contents of the Sharia standard under discussion? The first two slides that I used during my sort of keynote address before starting, those slides were not included in this one, and those are not part of the standard. Those were part of my keynote speech before we started. But what we discuss now exactly is the standard. So if there is not something not matching the standard, it might be a typo mistake on part of our secretariat team. Other than that, this is exactly the presentation for this one is exactly the same. And Brother Nasir Bajaja, Zishan Khan, Assalamu alaikum and wa alaikum assalam. Brother Nasir has a point. Would you please explain to us the practical application nowadays in the Islamic capital market? Brother Nasir, although I may request our honorable chairman for this one, but this might be a very fundamental, basic level question for this one. I'm not sure, Sheikh Hussain, would you like to take this question, or you feel that time may not permit this one? It's purely up to you, sir.
Brother Omar, this is out of the scope of the hearing session. We are here to get the feedback from our colleagues about the standard, about the articles of the standard. So explaining some general issues related to Sukuk or related to capital market or related to the Islamic banking industry or Islamic financial industry is out of the scope of this session. Thank you.
Thank you, sir. Sheikh Hussain, sir, there is a question, and I think we need to answer it, and we would like to have the input from the Sharia board. When do you expect the standard to be issued, inshallah? That is from an anonymous attendee, but this question is very important. So because market is waiting for it, so your kind answer on this is needed.
As I expect, or as I understood from the Sharia board, they are keen to issue the standard this year in 2025. But when it will, we cannot specify the time because we are still we are now in this hearing session, which is the fifth one, and we still have the last one. And after that, the Sharia board will go through the feedback and all comments, review them again, and after that, we need to review the draft itself, the wording of the standard. We have a special committee to look after this. And so it's still we have many things to do before issuing the standard. So we hope that the standard will be issued this year in 2025, inshallah. But whether in the first half or second half, I cannot give a specific answer because it has not been determined even by the Sharia board itself. Thank you.
Sheikh, if you allow me to put two questions that we received from the market related to this one. One was very quick about till when you are going to take the comments. I think public hearing sessions will end on 10th, inshallah, 9th of this month, inshallah, when we hold the last public hearing in Bahrain. And roundtable is not decided. Obviously, it was proposed, but it is not decided that it will be there. But that will not be a public session. That will be, even if it is held, it will be only for the experts. But the question is, can we receive comments till now, or do we have any date for that, or we have written comments are closed?
We can. The question is to me, Brother Omar?
Yes, sir. Yes, sir. Yes, sir.
Yeah, we are still, the door is still open. And we because as you said, and I said, and Brother Abdurrahman Saadi said, we still have another hearing session. So the door is still open to either to present the comment in the session or in the hearing session, or to send it in writing to AAOIFI directly. So the door is still open and has not been closed yet.
Sheikh, another comment that we received several times individually as well as in writing, I would like to mention, because this is for benefit for all the participants here. That is about the effective date, sir. So if it is approved within this year, does it become immediately effective? Or because this has been an issue, because you know that it has impacted the market earlier for some of other standards. And this is something that a lot of regulators and individuals have approached us and entities have approached us. So that question is also very crucial, that if it is approved within like second half of 2025, does it become immediately applicable?
For sure not. For sure not. And the discussion now is to give 1 year, 2 years, or 3 years. This is what the Sharia board is discussing. So because the standard is a new standard, very important standard, and long at the same time, and addressing many issues. So the industry will need quite long time or reasonable time to understand the standard before starting the implementation of or applying the standard on the new issuances. So there will be time, and as I said, the Sharia board now is discussing whether to give 1 year, 2 years, or maybe 3 years, inshallah.
Thank you very much, sir. I think this is a sigh of relief for a lot of our industry participants today. And this is like, may Allah keep us on the right path. This is very important. Sir, there are two quick comments on the administrative side. Let me answer them. Brother Zishan Khan has asked, is there possibility of coming physical session or hearing held in Pakistan? Actually, it was already held, my dear brother. You unfortunately missed it. So that is a bit unfortunate. The second question is from Hani Abdulaziz. When is the next hearing session? Brother Abdurrahman, next hearing session is on 9th of February, like after 9 days from now. It is in Bahrain, physical session. That will be primarily in Arabic. That is the detail. Brother Abdurrahman, it will be conducted in collaboration with Bahrain Association of Banks. Brother Abdurrahman, have we finalized the venue of the meeting, of the public hearing?
Yes,
or
yes.
not yet? Okay,
Yes.
please, if you can explain further for the participants.
Yeah, I can write it here. It is in Swiss. It is in Grand Swiss Hotel next to City Center Mall, and it will be from 4 p.m. to 9 p.m. Inshallah.
Inshallah. Okay, so those of you who can attend, who want to attend physical session and attend in Bahrain, please, they are all most welcome. And particularly anybody in Bahrain today who is attending this one are invited. Please join us on that day.
Also, Brother Umar, I want to mention that our next Sharia board meeting is on 13th February. So we hope that we receive all comments before this meeting. It will be better, Yani.
Okay, thank you very much, Brother Abdurrahman. So if anybody want to send written comments, please try to send them by, I would say that by 9th or 10th, because if meeting is on 13th, so it is better we have 2 to 3 days to add them to the already received comments. So anybody who want to send comments in writing, please send maximum by 9th or 10th. Thank you very much. We have comment from Brother Mikhail Sanusi. Assalamu alaikum. Allah reward your effort. Thank you, brother. My suggestion is that let there be 2 documents for AAOIFI Sharia standard. One for the main content of the standard and another for the commentaries and explanation on the standard, because the content used to be ambiguous sometime. Thank you very much, Brother Mikhail, for your kind comment. We'll just pass it on to the relevant Sharia team as well as to the Sharia board, that if possible, and to what extent they consider it a feasible option. So that comment is well taken and it will be passed on, inshallah. Thank you very much.
Brother Amr, as we did in the previous sessions, you determine the article, the number of the article from so and so until so and so, and we
Yes, sir.
give a couple of minutes to receive comments on these specific articles, and then we will move.
Yes, sir. We
Otherwise,
will
we
do the
will.
same thing, sir, section by section. So the scope is the first section. So by chance, it is only one slide. So I stopped here. So, once we take all the comments on scope, we move to the section 2. We do exactly, so we'll do section by section, inshallah. Brother Sadaqat has a question. Adoption of this standard would be mandatory to all IFIs globally or optional. Obviously, it will depend on the regulatory adoption. Those countries where regulatory it is adopted, it will be adopted. There is a comment from Sauda. Is it acceptable to operate both Sukuk and conventional bonds in terms of depositing money, given that this is only one central bank that takes all deposit from conventional bonds? If it is not acceptable, what should be done to ensure compliance with Sharia standards? Sheikh Hussain, would you like to answer this question? The question is not very clear, but probably it's talking about the dual banking system where, like, the proceeds of Sukuk and proceeds of bond might be going to the same place. So would you like to answer that, sir?
I don't know. I'm not sure if she's a sister or brother who is giving the question, but here, if the central bank is not having an Islamic deposit or Islamic or Sukuk is just having conventional, then this is this is the situation we have in many jurisdictions. So it is not related to the standard we are now discussing. This is a special
But they are
situation.
talking about operating both, sir. So the point is, okay, maybe I'm not understanding the question
question
fully,
is
but if
not,
I try to understand question, it is operating both Sukuk and conventional bonds. So the question is, for example, Central Bank of UAE issued Sukuk and Central Bank of UAE also issued bonds. So okay, let me try to understand my view in my understanding. So for me, yes, it is possible that proceeds of both Sukuk and bond are used by the UAE government. But the point is that Sukuk would be based on some assets on the back end. And Sukuk would be complying because UAE Central Bank adopts the OFI standard. So Sukuk would be complying with the requirements of this standard. While bonds will not be doing that. So operating both like dual banking system being managed by the central bank uh, does not automatically make Sukuk haram. You will have to see if Sukuk issued by UAE Central Bank or any other central bank for that purpose are complying with the requirements of Sharia as entailed in this standard. If it is happening and there is underlying asset which is Sharia compliant and that product is Sharia compliant and the contract of Sukuk is Sharia compliant, then issuing Sukuk is halal and investing in that would be halal, while central bank doing both functions is their choice.
You're right, Brother Omar. Yeah, I got the answer. Now we see not only the central banks, we see corporates, companies, I mean, they issue Sukuk and issue bonds at the same time. It doesn't mean that issuing bonds is preventing them from issuing Sukuk. If they are ready to apply the requirements or to adhere to the requirements of issuing Sukuk can be issued. And at the same time, when they issue bonds are haram, not acceptable from Sharia point of view, and the sukuk will be, of course, Sharia compliant. So we have many companies. They issue both, and we have governments as well. They issue bonds and issue sukuk, like Indonesia, like UAE, like Saudi, and Bahrain, many other countries. So issuing bonds. Per se doesn't prevent them from issuing sukuk, as I said, if they are willing to apply the Sharia requirements of issuing sukuk.
So next comment is also an important question that is linked with the application date. And the question is by Brother Muhammad Usama Wakil, whether there will be a retrospective application. Means that any sukuk that have been issued by the time of the application date of the Sharia standard, would you have to apply the Sharia standard on transactions prospectively? That is, any transaction, any sukuk that is issued after the date of Sharia standard becoming applicable, or it will be retrospective, means that once it becomes applicable, you will have to correct the sukuk which were issued before that as well.
As we see in all Sharia standards, in end of the standards, there is a statement. It states clearly that whatever applied before the standard, even if it is not in compliant with the standard, it doesn't mean that these are not Sharia compliant. So whatever happened or issued, we are talking here about sukuk, whatever issued before issuing the standards will continue until their end, and the standard doesn't consider them non-Sharia compliant, even if they are not in line with the requirements of the standard.
Sir, I think this is addressed in Sharia Standard 29 also about change of fatwa.
Yes,
That change
yes.
of fatwa does not mean, because it will be a change of fatwa. So change of fatwa does not make other earlier fatwa invalid. It makes that what was done according to that was correct. Now new fatwa applies. Thank you very much, sir. Brother Waqarul Abdeen, Zainul Abdeen has a comment. Is the exposure draft updated with the comment suggestion, or it is the same original draft for every public hearing? Brother Waqar, this is the same exposure draft that we are having. Actually, Sheikh Hussain, this question I received from others also. So till the time we are conducting these public hearings, it is the same original draft. However, there is a question, Sheikh Hussain, that once we incorporate all of the comments and take the final decisions, would it be more appropriate to issue another exposure draft before finalizing that these are the comments that have been incorporated and these are not incorporated? I recall there was one issue of one of the Sharia standards, Brother Abdurrahman. If I remember, there was a decision of the Sharia board that if there are significant changes to one of the standards exposure draft, then at times it might be more appropriate to issue another exposure draft before we finalize. Brother Abdurrahman, can you add to that? Because I remember it happened in case of one of the standard when public had some comments that significant changes were brought, but after bringing those significant changes, it was not exposed to public again.
I think Sheikh Hussain also can answer.
This is not a common practice in the process of issuing the Sharia standards, but it can be discussed in the next meeting of the Sharia board, and we will see what the Sharia board will decide, taking into consideration the importance of this standard.
Thank you very much, sir. So I think it's not decided, but it may happen. So we'll take it to the Sharia board as a suggestion by Brother Waqar. Thank you very much, Brother Waqar. Brother, there is a question from Brother Rehan Ali. Can we join that online? I think that he's talking about a public hearing for physical in Bahrain. Brother Abdurrahman, will that one be available online as well?
No, brother. يعني physical, because it's
Okay,
not.
it will be only physical. It will be only physical.
But if
Okay.
he will attend and comment in English also, we welcome him and we can write.
Yeah. Okay, thank you very much. So that will be mainly in Arabic, but comments in English will be welcome, like it will have happened in all the public hearings that were conducted in Arabic. Comments were taken in English as well. Brother Hani Abdulaziz has a question. Can you send the audience an invite to? Yes, sir.
Similarly, if anyone wants to ask in Arabic.
Yeah, today, exactly.
Okay,
If anybody, even if anybody has a comment on the Arabic text, if anybody has a question in Arabic, please feel free, because this is the only online public hearing. So it is available for the Arabic audience as well, but we kept English as primary language. Sir, there is a question. This is again, it's administrative. Brother Abdurrahman, we received a comment from Brother Hani Abdulaziz. Can AOFI send the audience an invite for us to make the travel arrangement? Sister Noof, may I request you that we have all the email addresses. So we just pass them on the invite for the 9th February public hearing. So if any one of them want to join, they can manage it. So if we can send that invite to all registered participants today, it will be good. We have comment from Brother Dr. Shafiqur Rahman. I'm Dr. Shafiqur Rahman from Bahia University Law School. I have a short comment on the translation from Arabic to English. The word yajib has been translated in many ways like it is required, must be. The translation need to be harmonized, please. Thank you very much, Brother Shafiq Rahman. I think we keep this comment and we pass it on to the translation committee. And our respected, dear respected brother Yusuf Azim Siddiqui, who actually did the initial translation, is also here. While I can well understand that in some situations the context might be requiring something, but still it is better that we stick to a consistent translation and consistent terminology. Brother Yusuf, I expect you will take a note of this one and we will pass it on, Brother Abdurrahman, to the Sharia committee as well. Not only in this standard, but also how we have used the term and how we have translated in other standards also is relevant. Thank you very much, Dr. Shafiqur Rahman, sir. We have comment from Megat H. Hassan. Can someone please project the correct slides in tandem with the presentation with Brother Umar? As currently the slide project on Zoom seem to be stuck on very first slide, cover slide. Okay, I will stop share and I'll share again if you are having this problem. At times it happens. So let me do it again. I hope it works better now.
Yeah, now it's better.
Yeah, now it's okay.
Okay. We have comment from Brother Michael Gifforty. Assalamu alaikum. Thanks for organizing this session. Gulf Capital Market Association represents participants in the Sukuk market. Will Standard 62 apply equally to Sukuk that may be issued by sovereign governments, which may not be permitted to use state assets as foreseen by the standard? Sheikh Hussain, I think this is, although he put this question on the scope stage, not at the relevant stage, but this is one of the most fundamental questions that we are receiving. We have received this question earlier as well, that to what extent and under what circumstances that state assets can be used, and what would be the situation of ownership or eventual ownership transfer in case of these. So I think, Brother Michael, I think this is something that is being discussed at the Sharia board currently based on the comments that we have already received. And actually, Sheikh Hussain, if you ask me, this is one of the points which should be taken to the round table as well, with some of the real experts sitting together to find out the real solution to these type of questions, why it would be necessary. So this is again one of the most crucial questions that we have received, and I'm sure Sharia board is taking it into consideration. Thank you, Brother Michael, for this one, and let's be assured that your question is being taken care of by your comment is being taken care of by the Sharia board. I don't know, Sheikh Hussain, if you want to answer it at this point.
As you said, this is one of the most important questions. A question we received from even from some institutions. So we should understand that, and as per the standard, even the old standard, but this standard in particular, we have many structures for issuing Sukuk. Having these structures, it doesn't mean that all of them will be can be used, I mean, to issue sovereign Sukuk. For sure not. We need to know what is the proper structure for issuing sovereign Sukuk, taking into our consideration the special nature of these of the assets, because these assets are sovereign assets. Therefore, today, for example, if we look at the Egyptian Sukuk, the Sukuk has not been issued on the title, on the assets where the title is required to be transferred from the government to the Sukuk holders, because these assets are sovereign. They use Haqq al-Intifa', usufruct right, where the Sukuk holders will own the usufruct only. not the assets, or not the title, will not have the title of the assets. Similarly, in the UAE, they use the حق الانتفاع. In Saudi, they use مضاربة. Some other countries like Pakistan, they issue sukuk on the sovereign assets, but they get special permission to issue sukuk from the parliament and from the authority there to issue sukuk on these assets. So sovereign sukuk, issuing sovereign sukuk always is not something easy. We need to think about the structure. We need to take into our consideration the nature of the sovereign assets and select the proper structure. So as per the standard, we have, as I said, many structures. We need to know which one is suitable for the country that we are going to issue sukuk according to their jurisdiction and laws.
Thank you very much, Sheikh Hussain, sir. Allah bless you. Next question is from Brother Najibullah Faizi. A quick question. Is there any accounting standard public hearing session on Sukuk? FAS 29 exposure draft has been issued earlier. And before we conclude, probably this standard and that FAS 29 will be finalized more or less at the same time, inshallah, within this year. So probably a couple of public hearings will be conducted on that. Dates are not finalized because we were waiting for the Sharia standard to take a final form before that. There is a question from anonymous attendee. Assalamu alaikum. As AAOIFI is set to finalize the Sukuk Standard 62, which focuses largely on market operators, do you have any ongoing arrangements concurrently with the IFSB on the Sukuk prudential standards from regulatory and supervisory perspective in order to reinforce the harmonization and best practice requirement? Thank you very much. It's a good comment. Actually, IFSB's standard on the capital market instruments is already there. That is a very good standard, quite robust standard. We have an MOU with the IFSB of working together for the benefit of the industry. In addition to that, Islamic Development Bank, which is a common entity for AAOIFI and IFSB, also encourages joint activities, which and even a joint forum was being discussed for some point of time. So at this point of time, what we have decided with IFSB is that we have more clear mandate for both of the bodies. So while AAOIFI develops Sharia accounting, auditing, governance, and ethics standard, they primarily develop the prudential standards, which means that the overlapping functions between the two bodies are very minimum. So if I remember correctly, that is standard number 19 on the capital market instruments, which is quite robust, very good standard. I think that their capital market standards are good to ensure the robustness and the risk awareness of the market. Yes, we will be open to work further with them, but at this point of time, our mandates are separate, particularly with regard to Sukuk. So presently, we don't have any project to work with them on that part, and probably it might not be needed. Thank you very much for your comment. Just a request to all the anonymous attendees that if you can rename yourself, Zoom allows it to rename, so that we can record your comment with your name. That is very important. And now we have our dear brother Muhammad Abdul Razak. Assalamu alaikum and welcome, brother. Assalamu alaikum. Question on clause 3.5. Okay, let me just reach to clause 3.5, brother Abdul Razak, then we'll take your question. I keep this one open. Brother Dr. Shafiqur Rahman has suggested that instead of yajib, the translation should be shall, as it has assertive legal emphasis. I think in our other standards, normally we use shall. We'll discuss it with the translation committee, inshallah. Thank you very much for your kind comment. We have comment from Brother Tariq Al-Ghamrawi. Again, this comment relates to Article 5.5.1.5. We will take it there. Miftahu Dibaba has requested share the slides. Okay, this is exactly the same as PDF. So normally we don't share it. We'll see if it can be shared. We have Brother Sharif Nail. Are there any proposed definitions between Sukuk and other financial instruments as per IFRS 9? I think the issue of accounting as per IFRS 9 financial instrument would go to the accounting side. We'll take your comment and pass it on to the accounting team that will be working on finalization of FAS 29. So we'll pass on your comment to the accounting team. And distinctive factors, as Sheikh Hussain has already mentioned, that are covered in section 3 of this standard. So the main distinctions are already there. There is comment from brother Umar Sharif Mahmood. You said Sukuk Islamic finance is different. My is that allowed to practice Sukuk under guideline, which is under conventional act. This is to say that Sukuk is practiced under guideline with the main act is for conventional bonds. Brother Umar Sharif Mahmood, you have raised a very pertinent question. The question, as I understand, is that the primary law is for conventional finance, conventional bonds. And an institution or a government issues Sukuk, which remains within the ambit of that act, but try to find a way within that act to create Sukuk. Sheikh Hussain, would you like to answer that, sir?
What you said is very accurate.
So we just simply move ahead on this point that this depends on different legal systems. Different countries have different legal systems. Even within the banking, in most of the countries, Islamic banking law is not different. Insurance law is not different. Takaful Islamic banking, they are generally operating within that act. That is something unfortunate. Till the time you are not able to change the whole legal system, you will have to live with this one. Thank you very much. I think you have a good comment, but we may not. This is what we try to find the solution within that act to make things workable. Brother Sadaqat has another comment. Is there any major difference between Sukuk standard issued by IFM and AOIFI? Sheikh Hussain, would you like to answer that?
My question is that is there a Sharia standard for Sukuk issued by IFM?
Sukuk standard. They have not issued Sharia standard, but they have issued Sukuk standard documentation. So they have Sukuk standard, Ijara Sukuk standard, and they are working on others. So that is the question.
They have standard documentation, I think, not.
Brother Sadaqat has not said Sharia standard. They did not issue Sharia standard. His point is probably that IFM issued a standard on Sukuk. And they generally claim that their standards are aligned with AAOIFI. And a couple of members of the Sharia board that IFM has are also our Sharia board members. So the question is whether IFM Sukuk standards on Ijara or other are compliant with AAOIFI Sharia standard. Brother Sadaqat, my quick answer would be, number one, this standard is in progress. It is not yet final. So once it is final, we will be in a better position to answer exactly whether it is fully compliant or not. Secondly, yes, they claim that their standards are AAOIFI compliant, and at times they invite us to their working groups, and our secretariat provide comments on that. But we have no means to ensure that all our comments have been incorporated by them. So this is the answer, that their standards are their standards. They are subject to their policy and subject to approval of their Sharia board. Even if they at times claim that are compliant with the AAOIFI Sharia standard, for sure this standard is not final. So this standard's compliance will only be possible once it is final, and then it is compared. But at AAOIFI, we do not create a comparison of that.
Just to add, Brother Omar.
Yes, sir.
Yes, Brother Omar. From
please.
If he is talking about their standard documents of the Sukuk, and according to the existing draft of this standard, I think if they want their documents to be fully compliant with this standard, they need to do some changes. Yes.
Thank you very much, sir. Now we have Brother Najibullah Faizi's question is linked with the earlier question about the central bank. So let me put that question quickly to Sheikh Hussain. While a bank or a company issuing both bonds and Sukuk, then how they differentiate their earnings on time of distribution, and how they keep, and what should Sharia emphasize about physical money, whether it should be kept together or separately?
Counting them.
Exactly. Sheikh, if you remember, we said that some of the Sharia compliance will happen through accounting only. Sharia compliant accounting will be the main for that. Thank you very much. So proper accounting records are needed. And if you see Sharia accounting standard number 34, Financial Accounting Standard number 34, that is for financial reporting to the Sukuk holder. That requires an entity, even if it's a corporate entity or a government, but that standard requires that an entity should keep appropriate record of financial results of the underlying assets that relate to the Sukuk holder. So the standard is called financial reporting to the Sukuk holder. So instead of a bond, conventional bond, it should be properly recorded and reported on the back end how this profit or loss is worked out that has been distributed to the Sukuk holders. Thank you very much, Brother Najibullah. Then we have comment from Brother Mufti Khwaja Nurul Hassan. Appreciate if the clarity will be added for the answer of retrospective in the Sukuk standard as well, which your good self has informed is already present in some other standard. Thank you very much, Brother Khwaja. I think it's a good comment. We'll just recheck the way it is written in this standard, because Sheikh Hussain has already clarified, and I think effective date will be appearing as well. So maybe Brother Abdurrahman and Brother Shakir, if we can make a note for the Sharia board that once we finalize on the standard, we just give some attention on writing the last paragraph of the standard, which clarifies about the effective date and about the retrospective application, that this will be applicable on the new Sukuk, not the old Sukuk, which is in line with our other standards, as Sheikh Hussain already mentioned. Thank you very much, Brother Mufti Khwaja. We have a comment from Sister Alvina Rahman Shah. Any Sukuk program already established prior to issuance of Sukuk should be grandfathered and used to issue a new Sukuk even after the issuance of a standard. Now, this comment goes to the next point, Sheikh Hussain sir. So now we have a Sukuk program. We agree that retrospective application will be there. But our sister is saying that if it is a Sukuk program, then within the program, whatever is there should be considered as a retrospective transaction. That is my understanding, because the master Sukuk agreements and okay, this can be two different situations here. One is tranches. There is a Sukuk program which has tranches, and one is Sukuk program in which each one of the Sukuk is an independent Sukuk. So for example, a government has a Sukuk program in which they issue according to that program. These are not tranches technically. But they are using the same contract, everything, but they are doing new transaction every time. The second situation is there is a single Sukuk program in which tranches are coming. So if it is like, a Sukuk program in which tranches are there, the new upcoming tranches, will they be considered as exempt from this standard or not? And if yes, this question is not by sister, but this is question added by me. If yes, then till when? So for example, if you say that Central Bank of Bahrain has a Sukuk, Salam Sukuk program. Now, if they say that such Salam Sukuk program is never ending, so does it mean that that never ending program will always be out of scope of this one? So this question, I think, is very important, Sheikh. First, your kind views are requested on this one. And secondly, Brother Abdurrahman, I think this point needs to be taken to the board as well to make a clear decision on that part, that if there is already a program, will the new tranches or new issuances within the same program be exempted or not? And if yes, then till what time? It cannot be never ending.
Allah.
Brother Umar, I think this should be decided by the regulators after issuing the standard. And here I may mention the practice in the UAE, for example, regarding the programs, Sukuk programs. Here in the UAE, the central bank or the Shariah authority differentiates between two types of programs. We have some programs, there is a size for the program, there is an amount for the program. So, and if there is a new requirement, and they do multi-issuances, if there is a new requirement, the new requirement will not be applied in any issuances, will be done under the same program until they consume the entire amount of the program and they do new program. In this case, the new program should comply with the new requirement. But especially the government programs, there is no limit, no size limit. So in this case, the higher Sharia authority determined the couple of years, as if I'm not mistaken, 7 years for the program. So whatever program we have in place, and there are new requirements issued by the Higher Sharia Authority. The new requirements will be applied or must be applied after 7 years from the first issuance under this program. So I think seven years is very reasonable and practical period, because for sure they will update the documentation of the product of the program. Sorry, after this. Long time or after 7 years, I mean.
Sheikh, here there is a a very important question, and that is my personal question to you. Now you will be giving us 2 to 3 years time to implement. Now I as a consultant can create programs for each one of my clients. So at least I get like 10 to 15, like 5 to 10 years. Or if I give an amount, like I give, the company needs today 1 billion dirhams, but I give them a program of 100 billion dirhams. They can be exempt for 50 years.
Yeah, this needs to be discussed.
Yeah, I think for me, the program should be given still a reasonable time. In our Sukuk standard, accounting side, what we said that it will be prospective application, but if the retrospective, it should also be applied retrospectively, but that is accounting side. But what I'm saying, we said it should still be applied or retrospectively if the remaining number of years are more than 2 years. So for example, if you have a program already for 10 years and you just started the program, then we say that then you need to change the program and correct it. Or if there is a single issuance of 10 years already, the accounting you need to correct if more than 2 years are pending, because otherwise somebody can say, today I issued a 30-year Sukuk. Now that 30-year Sukuk is completely out of the ambit. So this is one thing. Again, this is my question to you and suggestion that we should consider that part when we finalize the wording on the exemption of the programs.
It's very important issue raised by who gave us or who sent the question. It wasn't not in our mind. So now we need to think about it, I think, and discuss it in the Sharia board. Because
so first part is Sheikh, that I understand, program should be exempted, but maybe a time limit need to be imposed. That is my understanding of what you say. Obviously, Sharia board will decide. But as I understand your view that program should be exempted, but eventually time limits have to be imposed. I think, sister, you got answer to your question, and I think it is a very important question that you raised, and probably it will help us improving the standard. We have comment from brother Sayyid Imtiaz Abbas Hussain. Assalamu alaikum and welcome, brother. The operation of the State Bank of Pakistan is on conventional finance, full-fledged, but also issued Sukuk with no window operation. I think when central bank Sukuk are issued, technically these are not central bank Sukuk, these are government Sukuk, and these are using the government Sharia compliant asset. That is a quick answer to your question. Okay, then we have the brother Tariq Al-Ghamrawi have a comment. Okay, this is the comment is on Band 517. So shall we take it at that point of time? It's about Marhuna Fidain Ghair Rabawi. Okay, he wants more explanation for that word, Yurjat Tasri. I think, sir, we can take that comment then. He wants more explanation to that band with regard to that Ala Usul Marhuna Fidain Ghair Rabawi. So I think we should take that.
If you don't mind, let us start moving to the articles.
Sure, sir. Sure. So, okay, so we then come to the definition section. In the definition section, we have the definition of Sukuk here. And then we have the issuance of Sukuk, with regard to the timing, also important here that the issuance of Sukuk against that are already in existence move off the balance sheet. Then we have put the requirement of control of the underlying asset and the capacity part. So that is explanation of the main definition, or it's part of the main definition that explains it further. So the question is, do we have any specific questions on or comments specific on the definition of Sukuk?
Seems they don't have.
Okay.
Also,
There are
brother,
some.
we
Yes.
can identify like at least, let's say clause number 1, 2, 3, 4, all together, yani, not one page, each page. Otherwise, yani, will not be able to finish.
No, sure, sir. We will go section by section, Brother Abdurrahman, but obviously we'll go by the section. So now we come to the section 3. Section 3 is about characteristics of Sukuk. So, and this answers, as Sheikh Hussain has earlier identified, that the question earlier raised with regard to the key distinction between Sukuk and the conventional bonds is also covered here in section 3. So do we have any comments specifically on section 3?
Here we have a question about 3.5, brother.
Yes, sir. 3.5, that was earlier here. Yes, that is from Brother Muhammad Abdul Razak. His comment was on question 3.5, risk of Sukuk are not confined to credit risk of the originator, and its credit rating is not limited to financial worthiness of this entity. His question is, it is mentioned, does it mean that credit rating agencies would have to take into consideration the credit worthiness of the underlying assets and the underlying projects? Is it a Sharia requirement for the credit rating agencies under this draft to extend their credit assessment outside the financial worthiness of the originator? Sheikh, would you like me to answer it, because we have addressed that issue partially on the governance side as well?
Yes, brother, go ahead.
Okay. Brother Abdul Razak, fundamentally, this standard is clarifying that since you are taking risk on the underlying asset, so it is not credit worthiness, it is the performance of that asset. So technically what happens that your question mentions that now it's not the credit worthiness of the underlying asset, it is the performance of the underlying asset and valuation of the underlying asset. So what we are talking about is that instead of the originator being liable, and the standard use the term originator instead of obligor, which is commonly used, because obligor means that there is a identified valid obligation on the party. While here when we talk about is that you have the right on the returns arising from the underlying assets, and you have the right on the underlying assets or business venture, whatever it is. So AAOIFI has issued on the governance side its governance standard on Sharia compliance and fiduciary rating for Sukuk and similar instruments, Sukuk and other Islamic finance instruments. Earlier we issued the governance standard on Sharia compliance and fiduciary rating for Islamic financial institutions as well. Because fundamentally Sukuk and Islamic finance transactions are not credit. Okay, some of them are credit like Tawarruk and Murabha, etc. But fundamentally, Sukuk are not credit. So technically, the assessment methodology need to be changed. AAOIFI has already issued that methodology. International Islamic Rating Agency is already working on that methodology. But how much time would it take to convince the credit rating agencies to come to this business? It will take time, but I can assure you that seeing that they all are now into second opinion with regard to sustainability and all that, so it means that they may come to this one as the market develops. But if the market is happy by having the credit rating of a Sukuk, which technically is not subject to Sukuk, this will not work. So Brother Muhammad Abdul Razak, the quick answer, although I try to explain, but the quick answer is that the Sharia standard clarifies the characteristics that underlying asset is the base. When the underlying asset is the base, it means that you need to assess the performance, asset management quality, fiduciary management of the underlying assets, and the ability of the underlying assets to give you returns. So this overall methodology completely changed. Thank you very much, Brother Muhammad Abdulrazak, for raising this very important comment. Is there any other comment that we received with regard to clause 3, section 3?
Brother Omar, I think there are one or two comments on clause 2 towards the end of the question and answer tab. There is clause
Okay, for
2.
3.5, we have got another question from Megat H. Hassan. For 3.5, would it mean that we would need to take into account risk related to Sukuk asset? Yes, quick answer is yes, based on my detailed explanation. Then about clause 2, Waqar al-Abdin, but he just mentioned about 2.2, but I think his comment, okay, this is his comment. Brother Waqar al-Abdin has comment, does it mean clause 2.2? So let's go to 2.2 again, just to quickly have a look. Does it mean that asset once securitized will never come back in originator's book? Does it mean purchase undertaking should not be executed? If so, issuance of Sukuk would be akin to selling business assets. I think it does not mean that it will not come back. It never says that it may not come back. Brother Waqar, I think this understanding obviously will be dependent on the type of structure that is used. And this is just the definition part. The type of structure addresses the issue in which situations the purchase undertaking is allowed. That is very categorically mentioned in different type of structures where purchase undertaking is allowed, and even at what value the purchase undertaking is allowed. That is already mentioned in the standard. So probably as we move ahead with the standard, you will find answers to your question. Thank you very much. And thank you very much, Brother Shakir, for identifying this one. Brother Shakir, if you can help us with any other question that is on section 3 or section 2 or 3. Yes, Sheikh Hussain, sir.
And here the purpose of this is to clarify the difference between the Sukuk as a Sukuk and the securitization. Because from Sharia perspective, every securitization, the certificates will be considered Sukuk, but not every Sukuk is a securitization. You know, because technically there is a difference between the securitization and the issuing Sukuk on a type not be considered from technical perspective as a securitization. So if there is a purchase undertaking, this will not be considered technically securitization. But from Sharia perspective, it is something different. Both of them are considered Sukuk. This is the purpose of this. It doesn't mean anything more.
Thank you very much, Sheikh. I think it is quite helpful. I can see some comments going to the chat window. Again, a very humble request. Please put everything in the Q&A tab, because otherwise we may not be able to go back and forth to the other window. So we have to close this one. I think there is one comment, Sheikh, about scope specifically that we need to quickly see. That is by Dr. Shafiqur Rahman. In the scope section, he says that the standard deals with various types of Sukuk. It does not deal with shares of companies, certificate of investment deposit, unit of fund, and investment portfolios. He wants to suggest that it does not deal with the shares of companies, certificate of investment deposits, units of fund, and investment portfolios, equity-based investment, real estate investment trust, insurance policies, etc. I think, thank you very much, Brother Dr. Shafiqur Rahman. I think we need to clarify not only the type of instruments, but also the classification of instruments that do not come into this. Sheikh Hussain, I think we need to have some improvement on the scope exclusions. Thank you very much, Brother Dr. Shafiqur Rahman. Now, there was one more comment on clause 2.2. Mufti Khwaja Nurul Hasan also has a comment on clause 2.2. Some points are included in the facility structures that the company will keep the assets in their book as trustee. So will that be contradictory? Sheikh Hussain, the same question on this clause 2.2, the trustee relationship. So if the company itself the originator become trustee itself, or becomes in some situations become agent itself to keep the title agent, particularly in some markets, what we call a title agent. So does it mean that it's a contradiction of this clause 2.2?
No, it doesn't mean. Because as I said, this is just a technical issue. Here we are not saying this is halal and this is not halal.
Okay, but
it will depend on on the legal opinion, accounting opinion, regulator opinion, to decide whether this can be considered securitization or not. But it is, from Sharia perspective, both are same.
Thank you very much, sir. Brother Khaja, I think there is one very important thing, that whether the company in the capacity of trustee keeps any asset or not, an agent and trustee does not keep assets in their books. The problem is that why in the situations where just to clarify this part, sir, I think this might be helpful for some other participants as well. In accounting, what happens? They say that a continuing involvement means there is no sale. So, for example, I am issuing Sukuk based on Wakala. I sold to the Wakala pool or SPV. But they say that if you have continuing involvement, now continuing involvement as trustee, continuing involvement for recovery, continuing involvement for any guarantee, IFRS would consider that that continuing involvement in any form means that sale was not absolute. So they will not ask you to keep as trustee. No accounting standard asks you to keep something as trustee if you are a real trustee. No, they say that you are becoming trustee of the asset that you sold and you are doing services related to that. So from IFRS perspective, it is no sale. It's not an absolute sale. So this is where the accounting issue, like, not because of being trustee, but because of continuing involvement, they say it's no sale, so you keep in your books. So this is a quick answer. The further accounting issues, obviously, we can discuss when we discuss FAS 29, inshallah. Brother Khaja Nurusal, about the same clause as another question. Okay, no, I think he has duplicated this question. Okay, so do we have any other question about clause section 2 or section 3? Okay, so then we move to section 4 and for parties to the issuance. So this section 4 is about parties to the issuance. One thing I emphasize every time, that the originator term is replacing obligor, which is commonly used in the market. This is fundamentally a change. People don't note it down, but this is a fundamental change in actual understanding of, like, the Sukuk structure, that this is an originator and not an obligor. And this answers Brother Muhammad Abdul Razak as well. So do we have any comments on section 4? Brother Hassan Khan also has a question on to clause 2/2. Brother Hassan Khan, your question is, okay, just a question, I think. Okay, how does the complete off-balance sheet treatment of underlying asset affect the financial reporting and risk profile of the originator? I think, Brother Hassan Khan, this is the point. Risk profile, when we sell the asset and we don't control the asset, we don't have the risk. So actually, this is about reflecting the right risk profile. While you have raised a very good and fundamental question, but this question is coming from the same structure. If I sold the asset to you, who has the risk? If I sold it, and as per Sharia, it's a genuine sale, yes, there can be issues according to legal system, but the sale is there. I sold to you. Who has the risk and reward of that? Who carries the risk of that? You carry it. This is what requires off-balance sheet treatment on my part if I do not control the asset. If I sold them, or if new assets were purchased, but the control was not with me, and the control means risks and rewards, substantially all risks and rewards incidental to ownership of that were not with me, they were with you. So technically, it becomes your asset, not mine. If it is your asset, it should be in your balance sheet, not mine. Sheikh, you want to add something on this one? Because normally Sharia standards don't go into accounting part, but here consciously you have touched upon a little bit aspect of this part. So you want to add something here, sir?
No, brother.
Okay, we have now one comment on section 4. For 4.3, how would this provision, trustee as a party, apply to jurisdictions that do not have common law concept of trust? It's actually a good question. So, Sheikh, here I had my comment also that in some situations, there is no trustee, but agent and title agent concept is there. So the question is, maybe by default, the agent or title agent doesn't become a party, but that question is actually good. That's in some legal system, that concept of trust, like common law, is not there. And in some of those markets, you will find terms like agent, title agent, service agent. I'm not talking about a service sukuk. Service sukuk is different. Service agent sukuk is different. But in a normal sukuk structure, which might be a ijara sukuk structure, there can be a service agent appointed or a title agent appointed. So this is some of the comments that I even myself I had noted that we have taken only the trustee form. Similarly, Sheikh, in the markets where SPV concept is not available or SPV concept is pure conventional, so it is not available for Sukuk. In those markets, at times, Sukuk are created without trust. When they are created without trust, like the trust system and everything is in place, but because that SPV law is not applicable on Sukuk and for example, it's applicable only on future receivables or current and future receivables. So for other purposes, the securitization and SPV law does not exist. So it means that you cannot, either you create a corporate entity, which will be subject to taxes and everything. Otherwise, you do not create a SPV. Sheikh, similar question would be like in your UAE market, people have like banks have created without SPV based on Mudarba in their own investment pools. And this has happened in UAE and this has happened in certain other countries as well. So where the trustee, I think we might need to clarify that it is not fundamental that all transactions may have trustee. It may happen without trustee as well. And the second part is that if trustee is not there, but a type of agent is created to replicate the functions of trustee, how we cover it in this parties to the issues section.
Brother, here we are not saying that having SPV is a must. In 4.3,
that I know, sir. That I know.
Yeah, is usually a special purpose vehicle. But if you have any other type, it's fine. It's not a Sharia requirement to have SPV specifically. Regarding the trustee, and from Sharia perspective, even the agent is a trustee. So even if we don't have trust law in place, and we will appoint someone or a legal entity as a wakil, from Sharia perspective, the wakil is a trustee.
Excellent,
I mean,
excellent. Sir, can we clarify it somewhere? Can we clarify it somewhere to answer the question?
Yeah. It can be one of the comments to be discussed with presented to the Sharia board, inshallah.
Okay. Thank you very much, sir. So this comment will be taken to Sharia board, considering that if we can put some explanation to trustee that here the trustee does not necessarily mean a trustee according to the conventional trust law, but here we are talking about a trustee who functions to keep the assets and title, etc., which can be appointed under a wakala contract or something. Thank you very much, sir. Brother Osama Wakil has suggested that his two questions are skipped, so let's go back to his questions. Sir, in retrospective application discussion, as per this standard, the credit rating of the instrument is done on the standalone asset basis, irrespective of the issuing entity rating. And the banking institution holding the asset will have to keep the risk weight asset under Basel regulation. If the retrospective application is done, then on renewal date, it's quite challenging on the asset holding institution. Again, your comment is well taken. I think we cannot answer this one. Yes, we'll consider it as a practical impediment and we'll take it forward to the Sharia board, inshallah. Brother Osama has another comment. He mentioned about his two comments on the earlier section. So let me try his other comment. I'm sorry, we have so many comments received. Okay, now I found his other comment. Brother Osama Wakil's second comment is, if the asset is actually unproductive as the originator didn't have revenue in earning stream from that asset, but just to make compliance that the Sukuk should be the asset back, this would be a problem for a credit or for a rating agency. Brother Osama Wakil, I think in that situation, you are talking about a hybrid sukuk which actually generates return from the tawarruk transaction, not through the assets. So in that situation, actually considering the back-end asset, obviously credit risk to that extent will always be considered. But further details about this might not be subject of, I think, today's discussion. Thank you very much, Brother Osama, for having good comments. Then we have any other comments on this one? Okay, Brother Anwar Misbah Subra, Assalamu alaikum. He has comment about how about SPC and SPE. Brother Anwar, your comment need to be more clear. You want them to be part of the trustee definition 4.3, or you want them to be added as parties of issuance of sukuk? So kindly clarify your question, please.
These are different names of the SPV, Brother Omar. In
Yeah,
some
no, but
jurisdictions,
the question is yeah, for sure.
SPE.
Yeah, exactly. But I just want to understand his question in more detail. Thank you very much, Sheikh. Okay, so okay, then we have
we go to 5.
no, I'm just taking quickly trying to see if there is a comment on this one. Okay. There are some general questions, so I just want to make sure that we have a okay. Now we have on 4.3. Okay, Sheikh, this is a question by Brother Sadaqat that on 4.3. He's saying that in general, SPV is established by the same AAOIFI issuing sukuk and also issuing or originating, actually, technically, and also managed by the officials of the same AAOIFI. Is it the right practice?
It's not, we cannot say it is a right practice or not, but what is the impact about the structure from Sharia perspective if the SPV is owned by the same institution who is going to issue the sukuk? This is addressed end of in the standard. We have a special section for the SPV, so it will come.
Thank you very much, sir.
If the SPV is, in a quick answer, if the SPV is owned by the bank, for example, who is going to issue sukuk, then from Sharia perspective, there is no difference between the SPV and the bank itself. And this should be taken into consideration when we execute the agreements between the SPV and the bank. So it will come. It's addressed end of in the section of the SPV, end of the standard.
Thank you very much, Sheikh Hussain. Now there is a very significant comment from Megat H. Hassan for part 4, and this is very important comment, sir. Would obligors, that is party required to purchase asset under VAT. So if there is a purchase undertaking, now that purchase undertaking normally is by the originator. But if it is by a third party also, so there can be two situations, normally by the originator. So would obligor be required to be defined as a party to the sukuk?
Because of the purchase undertaking?
Yes. And particularly if it is by a third party, like two situations. Normally 80-90% situation, it is purchase undertaking of the same originator. But maybe in some rare circumstances, it is a purchase undertaking of a third party. So if it is purchase undertaking of the same party, Sheikh, then maybe we don't need to define it separately. He remains originator, although as an originator he has a purchase undertaking in addition. But if a third party purchase undertaking is available, is it party to the issuance of sukuk?
Of course. Here we have not mentioned all possible parties. Here we mentioned the most important parties, but of course we have many other parties. We have accounts agent. We have underwriters. Sometimes we have many other parties, but we cannot mention all of them. Here we mention the main parties in this section, but there are many other parties, of course. So if we have a purchase undertaking, issued by a third party.
Again, guarantee
The
can be
third
there.
party
A
will
guarantee
be
by third party guarantee can be there, and then we have to
same
get
thing,
guarantor.
same thing.
There can
Of
be
course.
agents, 2-3 type of different agents. So, Sheikh, have we mentioned it that these are
Yes.
the most important of which are? So the wording
Yes,
says
yes.
the most important of which are. So the answer is that these 4 are the most important ones. But yes, there can be guarantors or undertakers, purchase undertakers. There can be different type of agents, and other situations also can be there. So dependent. So these are the 4 main that we have talked about. Then I think there is a hand raised by Sister Alvina Rahman Shah, and actually while we decided that based on time availability, we'll try that. But honestly, at this moment, if we request everybody to put the questions in Q&A tab, because the time seems to be like, we have just reached section 4. And we have to go maybe like 300 400 slides by tomorrow. So it's just a request that please at this point of time continue by putting your questions in the Q&A tab. Okay, then Brother Anwar has explained his question that SPV, SPE, SEC each has a different legal formation as a company or enterprise and can engage in business. Dr. Anwar, I think Brother Sheikh Hussain already responded to that technically they all fall within that. Dr. Sheikh Hussain, if you want to add anything to that, please. Otherwise, he's just saying that because of the legal structure of SPC, SPE, SPV, that can be different.
I don't think that we need to add clarification. I think it's understood. But anyway, we can put this comment and see what the Sharia board will decide.
Okay, comment will be taken for sure, Brother Anwar. Your
Okay.
comment will for sure be taken to all the comments that we receive here. For sure, they will be taken to that. There is one comment about green sukuk. I think that's not subject of today's discussion, so we'll drop that one. Next, we move to section 5. If we don't have any question specific, if we have missed any question about section 1, 2, 3, 4, please remind me if I have missed any question, because there are some questions which were a bit out of scope or not related to these sections, so we have skipped those. Okay, so now we come to section 5, one of the fundamental areas, that is the underlying assets of Sukuk. So what are and what can be the components of underlying assets of Sukuk? The section is like about identifying the type of Sukuk and what in different structures, what form they take. So do we have any comments on section 5 now?
We have one on 5.15.
Yes, there was one comment on 5.1 initially. This is Brother Tariq Al-Ghamrawi. The draft kindly specify the benchmark for closer price, 515. The issuance of Sukuk takes place on the basis of purchasing the underlying asset by the certificate holder from the originator. Then underlying asset should be purchased at the market value or closer to it in order to prevent a sham purchase. Okay, so the point is that it has to be a genuine purchase. In order to keep it genuine purchase, closer price, what does it mean? So we are saying that they should be at market value or a price. Sheikh, I think, shall we write it or a price mutually agreed, which is closer to market price?
Yeah, it can be, but of course it's mutually agreed, because this is an agreement. When we do the purchase, we do the purchase agreement.
Exactly.
But closer to it, this is an interpretation issue left to the Sharia board, who will approve the Sukuk. As I know, some of the Sharia boards they consider 10% more or less. Some other Sharia boards they believe that 20% more or less is not an issue. So it's an interpretation issue for the closer to the market value.
Do we need to put a clarification here? Because normally what is kept is that a margin is kept for 2 things. Number one, the risk margin of the investors, and secondly, what we call forced sale value. So when you get a fair value report, you will get a fair value and you will get a forced sale value. For what happens that the fair value is the one that is in the market based on 2 willing parties expected as the proper price. But once you are in a pressure to sell it, there is a minimum price that you need to get. the 10 to 20% that you are talking about as a scholar's view also applies in the valuer's view, because the valuer has to apply a judgment considering the liquidity of the market and availability of the willing buyers, and based on that they put a forced sale value. So would it be more appropriate to put something as an explanation here, including the concept of forced sale value, because that is already available in the reports? So because forced sale value actually addresses the risk of investment for the investors as well.
That's a very good suggestion, Brother Umar. And we need to understand that the purpose of this is not to have a fictitious sale. That's it.
Exactly. Thank you very much, sir. Thank you very much, Brother Tariq. Sheikh, the next question was, it is 615. That is very important point about the pledged assets. If that is on the assets which are pledged against interest bearing. Yeah, 516, sir. The question is in Arabic, 516. If I translate myself, it is about that. Yeah. He's asking for further clarification on that point.
If the mortgage is not a conventional mortgage, or the assets are mortgaged for something halal, not prohibited, is it allowed to issue sukuk on these assets? Yes, it is halal. If the sukuk holders will agree to accept this risk, because issuing sukuk on this type of assets is a risky thing. So this is but if the mortgage is in favor of something conventional, this is not acceptable. So the article is stating that if the sukuk, or if the assets that will be used for issuing sukuk are mortgaged in favor of conventional loan, for example, then issuing sukuk on these assets is not allowed.
Sheikh, here I have a comment to be added here, if you allow me. Sheikh, there is one situation that you clarified, understood. Now, for example, I have a non-interest bearing, liability against which I have some assets, secured. If I create a sukuk based on mudarba, sukuk based on musharka, generally I think I would be okay. But for example, if I want to create a sukuk ijara or sukuk wakala based on that, which requires an absolute sale. Now, the situation is for ijara, sale and leaseback, ijara sukuk, I need to have an absolute sale of that one. If the asset is already pledged, how I can create an absolute sale? If it applies the same situation of wakala sukuk, that again, wakala sukuk, the models of Islamic Development Bank and other, the wakala sukuk require again an absolute sale. So if it was already pledged, how can I have an absolute sale? With regard to musharka, mudarba, others which do not require an absolute sale, they require creation of a partnership, and the counterparty agrees that, okay, it is pledged, but I am willing to take it into partnership. That is okay, sir. But if it requires absolute sale, don't you think it might still need some clarification here?
Pledged in favor of whom, Brother Omar?
Okay, so for example, I am a corporate entity. I have, for example, a Salam Bank providing me financing and whatever financing form is there, but my main plant is pledged against that financing. Now, what happens? I go to market and I want to issue sukuk based on the same plant. Now, if I issue mudarba musharka sukuk, which do not require an absolute sale, I simply create a pool of asset, and based on that, I create musharka and mudarba sukuk. And the sukuk holders agree that they don't have any harm in, they don't feel any harm in having the asset pledged to Salam Bank. Okay, this is okay. But if the sukuk structure requires an absolute sale from me to them, now absolute sale cannot happen because the asset was pledged to Salam Bank.
Who has the pledge interest on the assets if he give his permission to sell the assets?
But sir, Yeah. This
This is the
goes
case.
to the
Otherwise,
other party.
you cannot sell
So
them.
and I got your point, sir. So that it means that we need to go to maybe we need to explain it that in case of absolute sale requirement, you need to take permission. It has to be subject to their permission. Otherwise, it will be considered a non-compliance of the other side.
But shall we explain it here in this place? Because here the purpose is not to explain how you sell the pledged assets. This is not the purpose. It's just saying that if the assets are pledged for conventional, no way to issue sukuk on them. But if they are pledged in favor of something halal and you want to issue sukuk on them, this is not the proper place to explain how you do that. Maybe we need to add this in some other place.
Some other place where the absolute
But
sale is required.
it can be one of the, it can be a comment to be raised, inshallah.
Okay, so Brother Abdurrahman, Brother Shakir, we just take a comment from Brother Tariq that it might need Sharia board can consider if they feel that further guidance is needed here. And secondly, the issue that I have raised that whether it needs to be addressed at some appropriate place about that part. So that also can be considered. Thank you very much, sir.
Brother, as long as the question was in Arabic, so I need to answer the question in Arabic as well.
Yeah, that
because
is
we
also
did the
important,
answer
sir.
in
Please.
English.
Yeah,
So
please.
هذا البند بالنسبة للأخ السائل، لا أدري هل هو أخ أو أخت، لا أذكر. هذا البند يتكلم عن أنه إذا كانت الأصول مرهونة في قروض ربوية فلا يجوز أن نصدر عليها صكوك. مفهوم المخالفة أنه إذا كانت مرهونة في تمويلات مشروعة فلا مانع من إصدار صكوك عليها. فهذا الأمر أظنه مفهوم، لا أدري إن كان يحتاج إلى توضيح أو لا، أو إضافة شيء أو لا. لكن السؤال كان من الأخ عمر أنه ما هي متطلبات إصدار الصكوك على أصول مرهونة. هذه مسألة أخرى تحتاج ربما إلى توضيح في مكان آخر ليس في هذا المكان.
Thank you very much, sir. Okay, so we have. Okay, so this is question by Brother Zuhair Abdul Razak about the same point. He has raised the question that how does the standard ensure that underlying assets are valued according to their true market value, especially in cases where the value changes over time, and how is transparency maintained in the valuation process to avoid manipulation or conflict of interest? So again, I'm not sure that we can write something, but if you would like to answer this part about the same market value, how to determine market value and how to avoid conflict of interest on that part.
The market value which should be considered is the market value at the time of doing the issuance.
So again, that is not into the hand of the Sharia standard or Sharia board. That has to be addressed according to the, the valuer has to be like appropriate valuers to be appointed, competent and independent valuers and all that. Okay. Brother Mufti Khwaja Nurul Hassan has raised a question about, now Sheikh, this is also a good question because he raised the question that for section 516, the term pledge has been used. And so he says that the term pledge may be replaced with hypothecation as well. Now, the point is that in Arabic, we use rahan, but or marhuna. But what happens that in legal language, you may have pledge, you may have mortgage, you may have charge, you may have variable charge, you may have hypothecation. So these are all different types of what we call rahan in English, in Arabic. So the question would be, because it is a significant issue, so we say, okay, it's not pledged, but it may be under a variable charge, under a moving, a variable or moving charge. It may be under a different type. So Brother Khwaja Nurul Hassan has added to the hypothecation, but we need to do either of two things. Either we find a more appropriate translation here that covers all of them, because the term charge is also used. These all are terms used. Brother Yusuf Siddiqui, particularly if you can make a note of this one, because this has been an issue in other standards as well, that the issue of translation of rahan and different types of rahan. So sir, one option is we put a footnote. For the first time where we use term rahan, we use a footnote, and in footnote we clarify that for the purpose of the standard, the rahan may take different forms including this, or any other legal form that is prevalent in that country. This is just one thing that is coming to my mind. Otherwise, we need to find a more appropriate term as a single translation.
That's a good suggestion, Brother Omar. Or we may add a definition for the rahan end of the standard in the section of the definitions. So where we cover all of these types of rahan in the English language.
Okay, sir. Then we have again a comment from Megat H. Hassan. For 1515, would it be necessarily mean that a third party is required to be appointed to a certain market value, or would it be sufficient if parties agreed at what would be the market value of the asset? And the earlier question was about, conflict of interest issue on this part. So if you just assess yourself, it would be more like mutually agreed value. But Sheikh, what is the answer to this question? Does it need more clarification?
I don't think so. We should leave something for the Sharia committees or Sharia boards to decide on. We cannot address every single issue. Here we are saying it is a market value. How will you decide the market value? For sure, it is a technical issue.
And technically, it's a governance issue, not a Sharia issue.
Not a Sharia issue. But of course, the Sharia board, when they present the value to the Sharia board, the Sharia board should approve this value based on the process they applied to reach that value, which is the market value. So it's not a Sharia issue.
What you are saying, should it be explained somewhere? What you are saying is correct. We don't need to put it as a requirement, but should it be explained somewhere that whatever you have said?
So, but I cannot decide on behalf of the Sharia boards. It can be presented to the Sharia board to discuss it. Inshallah.
Noted, sir. Noted. Okay, Khwaja Nurul Hassan again has a suggestion. Okay, his suggestion is exactly about NOC for sale should be added in as before paragraph 516. So we just take your comment to Sharia board. We'll see what they see. Okay, then we have a comment from about. This is a comment from Professor Adam M. Abu Bakr, and what he says that, what about making a promise to purchase the asset at the initial price during the contract without waiting until the maturity of the sukuk? Is there any need to include a qualifier to avoid this type of situation? I think, Brother Professor Adam Abu Bakr, this is already covered in the standard that when and in what situations the purchase undertaking can be issued. So we reach those sections, we'll find that one.
We have section 6. Or article 6.3.2 is for the purchase undertaking.
Thank you very much, sir. So we'll just reach there shortly. Brother Anwar has the same question about the term closer. So I think we just close this question. Okay, there is a comment from Brother Mikhail Sanusi as regard 516. What if the underlying asset has been pledged as a security in interest-free transaction? Okay, I think it's the same question that was there in the Arabic, exactly more or less the same question. So we already answered that, sir. Okay, Brother Osama Wakil has a good comment here, very good comment actually, sir. The question is, he said that in 515, why not they mention it should be an arm's length transaction? This is a very good comment, Sheikh, that that from the legal perspective, it's a good terminology to use here. That again, it has to be according to market value, but even if it is not market value, it should still be arm's length. That is actually a fundamentally good point.
Yeah. But this is on the same article, Brother Omar?
515, sir. 515. When we said market value or close to it, so he said that we add this as that it should be an arm's length basis. So technically, it's a very good legal suggestion that if we write it arm's length, it covers and it is better understood in the legal system.
You're right.
Thank you very much, Brother Osama Wakil. It's a very good suggestion. We have another comment from Brother Anwar Subra, 511. Should a note be added? That structuring of should a note be added on 511? should a note be added that structuring of a special case portfolio mingled with tangible assets is not permitted to avoid sale of debt? I think sale of debt related provisions are referred to sale of debt standard, and I think it are mentioned here as well. So Sheikh, do we think that you want to mention it here? It is
It's
mentioned
covered.
and
Yeah,
it
it's
is
covered in some other places. It's
yeah,
very
it is
important.
covered at other places, and reference to sale of debt standard is also made. But probably why he's raising this question on 511, because it says that permitted underlying assets are tangible assets, this individually or in combination. Shall we say subject to other provisions, or shall we create also C, and we create a cross reference to where we put this sale of debt issue?
I think cross-reference will work, Brother Umar.
Okay, so thank you very much, Brother Anwar. We'll try to create a cross-reference because the issue is already covered in the standard. We'll just try to create a cross-reference to the point where it is discussed. Thank you.
Yeah, it is just in 5.1.3.
Yeah.
Not the next article, the one after that.
Yes. Exactly, because reference to SS59 is already there. So I think simply if end of 511, we say also see 513. I think that would be
Yes.
good enough reference.
Yes, yes.
Okay, Brother Khwaja Nurul Hassan has another point about this term 511. No, sorry, not 511. It was in 516
Shariah.
or 5. Surya, yeah, exactly. The translation of term Surya. So sham or fictitious, sham, fictitious, what would be more like,
We leave it to Dr. Yusuf and the translation
translation
committee.
committee. Thank you very much. So your comment, Brother Khwaja, will be forwarded to the Sharia translation committee and Brother Yusuf Azim Siddiqui. They will see what would be more appropriate translation on a consistent basis. On 515, Brother Khwaja Nurulsan has another comment. Dear says, as per Pakistan transformation journey, market value likewise items to be covered somewhere as explanation note. And okay, he's saying that market value of likewise items. But Brother Khwaja Nurulsan, when we do not impose, then it should be understood anyway. And this comment, anyway, any further guidance, if it is needed, will already will pass it on. Not an issue. Okay, then we have comment from. Okay, now this comment is pure general. Now again, coming to our very dear brother Muhammad Abdul Razak. So we now move to 5.2, requirements of ownership. So this section talks about the requirements of ownership of the underlying asset. Again, a very crucial section. Brother Abdul Razak has a comment here under section 523. Is it a Sharia requirement to ensure that contract of purchase and sale of underlying asset is enforceable as per relevant governing law and Sharia? Should we just limit it to Sharia and exclude local laws to avoid any contradiction in the definition of transfer of assets? So Sheikh Hussain, this is again one of the most fundamental issues that we are having with regard to what is sale acceptable by Sharia and what is sale acceptable by the legal system, and can a sale acceptable by Sharia be acceptable if it is not acceptable under the legal system?
The parties, when they agree or enter into the agreement, they agree to that the agreement is governed by the law. So if the law doesn't recognize the agreement, that means the parties have agreed that the sale is not a true sale, because they have agreed what the law has decided. So it is very, very, let us say, accurate. The question is very accurate question. And but the question is that based on this question, do we need to register the title? For example, if the assets are real estate, do we need to register the title in the name of the purchaser or sukuk holders? If the law is requesting that to transfer the ownership, this is the issue. As per the standard, Of course, it is better to have this registration, to have the agreement or the sale as a true sale from legal and from Sharia perspective. But if the registration, if there are difficulties to do the registration, the standard has allowed this on an exceptional basis, subject to certain requirements. We have many requirements required just to these requirements. The purpose of these requirements is to maintain the substance of the sale we are going to do. But if the sale is fictitious from legal perspective, cannot be considered a true sale even from Sharia perspective or from Sharia point of view as well.
Can I say in one sentence, just I'm trying to summarize what you are saying, and for my own understanding, I just want to say in one sentence, the sale should be legally enforceable even if the title officially is not registered.
So you are right. Therefore, the Sharia board has proposed a slight amendment on this article, on the wording.
Okay. So
But as
that
you said,
once it will finalize, it will be slightly improved to consider some of these comments to clarify this point.
صحيح. يعني if I want to summarize what is the amendment is stating, if I am not mistaken, that the sale should not be prevented from legal point of view.
Yeah, so sale should be, what I said was sale should be legally enforceable, but not necessarily transferred and not necessarily registered. This is what I'm saying.
Now, for example, if we want to issue, for example, sovereign sukuk, can we issue sukuk on a river, for example, or on a bridge or something like this, if the law is not allowing these things to be sold, for example? But if the law is saying that selling these assets is okay, is permissible, subject to certain process, then it is okay to do the agreement from Sharia perspective.
Sir, on a lighter note, sorry, my comment is that, but a lot of our Muslim countries actually they have this issue with this, but their assets are already pledged with the international multilateral, loaning agencies. So IMF and World Bank and Asian Development Bank and African Bank for Development, they all have assets under pledge for our Muslim countries. But when it comes to doing sukuk, it becomes a much bigger problem for our governments. Let's move ahead, sir. Okay. I think there is one comment, sir. I think, but this should be addressed when we have this SPV issue. The question is that government of Pakistan issues sukuk via SPV, but that SPV is 100% owned by government of Pakistan. So that is, I think that is the issue that is towards the end of the standard. So we'll come back to this point towards the end.
Omar, this is not only in Pakistan.
Yeah, it's in multiple countries.
All,
yeah, exactly.
In most, if not all, the sovereign sukuk, the SPV is owned by the government.
Then we have this, sir. What are the implications of purchasing underlying assets at a price? This is again 515, sir. What are the, Brother Hassan Khan, what are the implications of purchasing underlying asset at price significantly deviating from the market value? So what happens that if there is a non-compliance of this clause, would it invalidate sukuk? I think that is the question. What happens? What are the implications if it happens? So if we created a sukuk without agreeing on the market value, we created at more than market value, less than market value, any like share value. Like the point is, if we did it, would it invalidate the sukuk? Would it invalidate the sale?
And then we cannot claim that the sukuk is in compliance with this standard. That's it.
Oh, okay. We don't exactly. Thank you very much, sir. So what will happen? Sukuk is not compliant with this standard. Thank you very much, Brother Hassan Khan. You have your answer. 523. So we are on 523. 523. Stipulation for purchase of underlying assets sukuk should be suspensive muallaq on the occurrence of future and future. Okay. So Brother Waqarul Abdeen Zainul Abdeen has a question. Will enforceability opinion from a legal counsel or overall sukuk structure and document suffice the requirement to consider the contract enforceable by law?
Well, the possibility of being from legal counsel on the Sukuk social and the current requirements to consider the contract enforceable by law. Of course, we should rely on the legal opinion in this regard.
523. I'm just trying to understand, if, for example, what particular he's talking about, because purchase undertaking is also there, so, but the main point is about main, valid and enforceable by virtue of Sharia and law. Okay. Thank you very much. I think, Brother Waqar, I think you got your answer. 513, another question, Brother Sadaqat. If the underlying asset against which the sukuk are issued include debts, an AAOIFI issues Ijara Sukuk where the underlying assets are Ijara financing accounts of AAOIFI customers and assets are mortgaged with AAOIFIs. Is it permitted to issue Sukuk based on the mortgaged assets instead of AAOIFI's own assets?
And who is the originator? The AAOIFI?
So, no, AAOIFI is the originator and the underlying
And
assets
doesn't own
are
the
the
assets?
no, because brothers, I think Brother Sadaqat, let me try to understand his point. He's saying I am having ownership of Ijara Muntahiya bit Tamlik assets. Because of the normal practice, most of those Ijara Muntahiya bit Tamlik assets might be registered in the name of the lessee. Registered in the name of lessee, although I own them. So the question is, I own the assets, but these are already registered in the name of the lessees. Can I create a sukuk based on assets that I own, but whose title and possession is not with me?
In principle, we can. In principle, we can. But if we want to do the registration in the name of the SBB who is representing the sukuk holder, this will not be possible. So we need, in this case, you will go to the exceptional case or situation, and you need to meet the requirements mentioned in the standard.
Thank you very much, sir. So it is possible, subject to the requirements of the standard, from the perspective of Sharia, you still own the asset even if you don't have the title with you. So technically, you can do on that. Okay. Again, a comment. This is just a comment by Brother Zuhair Abdul Razak on 525. His comment is on 525 that keeping the assets under the ownership of the issuing entity of Sukuk may conflict with the principle of transparency. I think that is something that is understood, I think. But that is
in this case, Brother Omar, the standard is requesting to clarify this in the notes in the financial statements. The institution should clarify in the notes that the assets are owned by the disclosure. Yeah, is required. I'm trying to find the.
So disclosure is there to address the transparency issue as raised by Brother Zuhair. Thank you very much, sir.
Yeah, it is 5.2.5.6.
Yes, exactly.
State to state in the notes of the financial statements of the originator that the underlying assets of Sukuk are owned by the certificate holders.
Thank you very much, sir. Then we have Brother Anwar Sobra on 511. Okay, no, he just mentioned 511, but I can't find his comment. Okay, I'll go back to this one. There are a couple of questions which are unrelated. I'm just dropping them. Some questions are very general and some are very, so I'm just dropping them because otherwise finding the questions become difficult. Okay, now I find this question but Dr. Anwar, I can't find your question. I just find your comment. Okay, so
the Mufti Khawaja is talking about light sukuk term.
Okay, asset light sukuk. I think he's talking about asset light sukuk. Now, this term asset light sukuk is becoming very common in some parts of the world, particularly in terms of the sovereign sukuk, which are which are like, because sovereign assets might not be available all the time. So technically, there are different forms of asset like Sukuk, which are not backed by tangible assets because the tangible assets available with
Does it
some of
mean
the governments.
low fat assets?
Yeah, technically, and
Low fat.
or maybe the most common form is the same, Sheikh, like hybrid sukuk, where you have minimum of assets as a bundle, or the technical issue is that asset light sukuk are becoming important for like country like Pakistan, and some of the international multilateral donor agents and multilateral agencies are also pushing some of the governments that they go for asset light sukuk and not for the normal sukuk. Reason being that they feel that the assets, sovereign assets available are less. There are other issues as well, like in terms of Pakistan particularly, it's becoming more important because what happened that in government, the constitutional change happened several years back, and majority of the assets were transferred to province. Now the land is owned by provinces. The majority of the assets, health, all these things are owned by the provinces, and the federal government has minimum of assets, and it has defense. You cannot, you cannot have sukuk on F-16. So that is the problem, that you don't have those assets at the federal level that will be available to be pledged or to be used as a source for fully asset-backed these ones. So Asian Development Bank, World Bank, even they are pushing some of the governments, including Pakistan, to move towards asset-light structures. Now, asset-light is like mostly these will be hybrid sukuk, or mostly these will be so. But the question is, brother Khaja, the standard doesn't use that term, although hybrid sukuk term has been used. But technically speaking, if there is an asset like sukuk which is based on a revenue stream, not based on asset, and that revenue stream is acceptable as per this standard, then obviously that asset light sukuk will be acceptable. But if you bring an asset light sukuk and you want to make 10% of physical asset and 90% of debt, that will not be allowed by this standard, because as per the hybrid structure and sale of debt based requirements that are explained in this one, it will not be allowed. So effectively, by term, asset light will not be considered, but the structure will be considered, each one of them on merit. That's my understanding, Sheikh.
Right, Brother Omar. There are multi or different terms used in the industry that we don't find them in the standard, and this done by purpose. The standard, for example, has not mentioned the asset-backed or asset-based sukuk. The standard has not, in terms of the ownership, regarding the ownership, we don't have anything about the beneficial ownership in the standard, and so on. So what the standard is focused on the requirements. These are the Sharia requirements. You may apply these requirements under this definition or the other definition, this term or the other term. The standard has not addressed or has not paid any attention about these detailed, let us say, technical terms. Because if even for example, the حق الانتفاع, usufruct rights, we don't find it in the standard. We just mentioned the long lease term. To cover all types of the long lease term, you have leasehold, you have حق الانتفاع in some jurisdiction, you have different type in some other jurisdiction. So this is the approach the standard has followed to cover the maximum of the concepts we need in this industry. But if we focus on something used in particular jurisdiction and not in the other jurisdiction, here if we open this door, we may need not 100, we may need maybe 200 or 300 pages to cover all of these concepts and all of these possible terms.
Thank you very much, sir. I think it's well understood. Brother Anwar Sobra has another point on 5251. Without registration of ownership of sukuk assets, usually most official authorities do not recognize the asset sale contract as proof of ownership. In this, the ability to dispose the asset by the sukuk holder is defeated. Now, like Sheikh, the point is very well understood. Now the question is how you have addressed it in the standard. Would you like to explain it?
Yeah, يعني here the standard is the registration is required by the standard in
No.
all cases. The answer is not.
No.
But
But
if you
if it
want
is
to,
does not happen, how you ensure
yeah,
that in case of a
that's it.
failure, what
That's it.
happens?
Yeah. If you are not going to do the registration, if the registration is possible and there are no difficulties, you have to do it. But if there is something justify not doing the registration, so what are the requirements? Here, what there are many requirements listed by or mentioned or stated by the standard. If you want, we can go to them, Brother Omar,
Yes,
because
sir.
this is one of the question many people is asking or raising. Just a second. Yeah. Yeah. 525, Brother Omar.
Yes, sir. We are on 525.
525, yeah. Here we are talking about the ownership, and when we read this, we may understand that the registration is required. But then, end of this 525, it states that, where is it? Just a second.
It allows
However,
in the
if you
name
read
of the
after,
originator.
however, yes, Brother Omar. However,
Yes.
line 1, 2, 3, 4, 5, number 6. However, if legal
However, if
tax,
legal tax, yeah,
yes,
exactly this.
here. So then then the
Then these
following
are the
conditions
conditions.
must
The
be
next
fulfilled.
5251 are the conditions that if you don't register, then you fulfill 5251, 525, the 5251, 5252, 5253. If you don't register, am I right, sir?
Yes, you are right. Here we
Exactly.
have almost 9 requirements.
Exactly. So these are all requirements which apply if registration is not done. So Brother Anwar, the way I understand it, yes, we know that registration is necessary, and if registration is not done, there are risks of Sharia. But to cover that risk, these 9 conditions have been added by Sharia board to address this specific issue, because in some countries it is not legally possible to transfer, and in some countries it will be a double incidence of tax. So to avoid that double incidence of tax and to avoid that legal restriction that is there, so these 8 or 9 conditions which are there, these are the ones that will be applicable here, 7 conditions.
Yeah, the purpose is to maintain the substance of the ownership, if we may say, because if there is no ownership, no scholar in the world will say that the Sukuk is Sharia compliant.
Sheikh, one last question on this one, because I heard this question myself from a couple of people, and actually we had to we had this thing coming from different quarters. The question is, if we do it all, in case of default, if the structure does not allow that in case of default that can be transferred, then would it be still Sharia compliant?
Will not
Is that
be
for this
transferred.
standard?
Will not be transferred to whom?
So for example, I am issuing Sukuk and I'm not transferring the title I am keeping. So I meet those requirements that you mentioned about this 5.2.
Yeah, I got your point, Sheikh. But if you go to 5252,
exactly.
5252, yeah.
A legally valid deed should be signed establishing certificate holder title of the underlying assets, such as counter document, counter deed. I think Brother Yusuf Siddiqui, that better term here is counter deed. I think it was one of my notings. Counter deed is the legal term which is used here, not counter document. with the stipulation in the deed or in other Sukuk documents, such as the base prospect, the right of the certificate holders to request that the asset be registered in the name of the certificate holder and the name of their representative in the situation that require it. That is written, sir. My point is, if it is not possible, what happens? Would it be still a compliant product, compliant Sukuk or not?
I don't think it will be compliant, because end of the day, now we are not going to the register, but we should give them the right, according to this document, give the Sukuk holders to do the registration at their cost and expenses if they are willing to do that, or if they want to do that to protect their interest. But if we say in no case or no, you have no choice to do the registration, whatever will happen. In this case, we cannot say that the ownership is a true ownership.
Okay, Sheikh. Now I have another very important question, and that is my personal question, because this question was coming from everybody. I just wanted to clarify to public hearing. Now there is another question. Sheikh, what is the real form of ownership? So for example, there is an airport. And I say even that airport will be like, transferred. We will register the airport even in case of default. But in order to use that airport for an intended purpose, or to demolish it and make a housing society there, the question is, what constitutes a real ownership? Because real ownership means that you need to have the right to sell, right to dispose of, otherwise like gift, right to use, consume. So the question is, if I did it on an airport, and while even the government allowed, okay, you transfer even the airport title to you, but they don't give me the right to run the airport, to earn anything out of it. They don't give me right to demolish the airport and make a housing society out of that. The question is, probably, Sheikh, this is something which has not been explained to that detail in the standard.
Of course, because you give the most difficult example, which is selling the airport or selling something. As I remember, in Bahrain, when they issued, long time, not now, issued the first sukuk on the airport of Bahrain, they got the permission from the parliament to do so. But what will be the sequence if there is a default? I don't know. So if we want to issue sukuk on this type of assets, it will be very complicated. And of course, the standard just mentioned the general requirement, what we need to do, but what are the details? How will we apply this? What we will do? What will be the impact? What will be the consequence? Of course, the standard kept silent about all of these things.
Thank you very much, sir. Let's move ahead. I think there is a correction by Brother Arshad Rahman about base prospectus versus prospect. I think I noted it somewhere as well. He has not put the reference here, but I think Brother Shakir and Brother Rahman, we take a note at a couple of I think one or two places. Instead of base prospectus, the translation appears as base prospect, which needs to be corrected. We have another comment from Brother Waqar Zainul Abdin 5252 on this clause where we are showing some sukuk are substantially owned by individuals from secondary market and there is no general assembly meeting or for sukuk holder. How will sukuk holders convey their demand to register the assets in their name? Will each sukuk holder should become joint owner or an entity will represent that sukuk holder? I think it's an excellent question. Couple of these things we addressed on the governance side, but in the governance standard on Sukuk, we have addressed very little bit of it. But these are the questions that are very important. So technically, I believe, I'm not mistaken, but just Sheikh, if you correct, right now the trustee has this right on behalf of making sure of the stakeholders. But if trustee himself is the company or the originator or a subsidiary of originator, how it will happen?
It's a very good question. As you said, the SPV is representing them, but if the SPV is owned by the originator, then it will be an issue. But usually in the sukuk, this is what we see in the market. There in the prospectus, there are certain articles or clauses related to the meeting of holding a general meeting or a general assembly, whatever we call it, for the sukuk holders. and the decision is taken by the majority, and the process is detailed in the prospectus, in most of the prospectus of the Sukuk we have seen. So calling the Sukuk holders for a meeting is something possible and addressed in the prospectus of the Sukuk. So the
Thank you
Sukuk
very
holders
much,
can
sir.
be
Again, it's a governance issue technically, not a Sharia
it
issue.
is a governance issue.
Yeah,
It is a governance
yeah.
issue. Yeah.
Okay, then we have point on the same clause by Brother Mufti Khwaja Nurul Hasan to add in the discussion if the sukuk are issued and underlying assets are airport bridges, how the certificate purchase holder will bear the cost of registration. It will be so much that it will be constituted a real sale. The point is, if you are losing everything, Brother Khwaja, if you are losing everything, yeah, then you will still prefer to sell it and maybe make a housing society there. I think there is a comment from Brother Muhammad Imran. Why registration vary restrictions from Sharia point of view? What is different between? Okay, I think his question is not very clear on this part, Brother Muhammad Imran. You need to clarify it further. Brother Muhammad Usama Wakil has has mentioned in event of default, who is going to bear the cost of registration? I think it's the same question. So as if the cost is almost 10 to 15% of the value. My question answer is, if you are losing everything, you will prefer to put 10, 15% and get the asset in your name. Zohair Abdul Razak has another comment. I still believe there is a legal issue that needs to be addressed regarding keeping the ownership of the asset registered in the name of Sukuk issuing or originating. We are not using the term issuing. We are using originating company as asset. This is because disclosure does not prevent disposal, which creates risk to the right of Sukuk holders. Actually, Brother Zohair, a quick answer to your question is normally when the title is not transferred, a pledge is created. This is a very common practice to safeguard the interest of the Sukuk holder. This is a common practice, but Sharia standard does not put it as a requirement for that. But that is something Sheikh said, if we do we need to consider this factor that if title is not transferred out of the conditions, how to restrict that he cannot sell to anybody else. A pledge or a charge of rehen or any form of rehen need to be created as a condition. So shall we add it as a condition out of these conditions that we have made, that at least a legally restraining like, you know, a rehen or something should be there that he cannot sell it.
You're right.
Practically, it is happening, but is it?
Yeah,
Should
it's
it
happening,
be added
yeah.
as a condition? This is the question.
Yeah.
Thank you very much. Yes, sir. Yes, sir. Please.
When we read this 9 articles or requirements, what you said is understood. And how you meet these requirements, you may need to do what you have just mentioned, having rahan, having something to meet these requirements.
Thank you very much, sir. Just Brother Zuhair will take your comment to the Sharia board and we'll see if they want to add anything here. Brother Sadakat has a very strong argument. Again, he has an argument, so just as a comment, take it to the board. He suggests to disallow issuance of sukuk by government against airports, seaport, railways, roads, mean strategic assets. His view is that against strategic assets, sukuk should not be issued. It is his view. You can obviously take it to the Sharia board, whether we can take that strong stance or not.
It's a good suggestion. And today, in the recent sukuk, as in Egypt, for example, or in the UAE, they do the sukuk on the usufruct of the assets, not the assets per se.
So, Sheikh, I think then we may need to, like, you know, rediscuss this thing in Sharia board and maybe consider, because again, Sheikh, you will find both type of views. Some people are feeling standard is becoming too restrictive, but some experts like Khwaja Nurul Hasan and Brother Sadakat, you can see they have hands-on knowledge and they are trying to ask Sharia board to make things more strict. So you need to keep a balance as Sharia board, but this suggestion is itself important. Okay, there is just a reminder by one of our respected brothers that his comment is missed out. Abdul Khalid Muhammad Minhaj, his comment somehow has been missed out. So please allow me to just find his comment, because he reminded that his comment has been missed out. Brother Mufti Minhaj, your comment was very personal. I think that was the reason that I have put it. You just can record my email address, oansari@aofi.com. Sister Noof, you can put my email address on the chat window. Anybody who want to put any personal question like this, they can just approach me directly. That is about area of research, etc. that he asked for the question. So I think this is not for benefit of everybody. So anybody has some general question or general suggestions, please you can pass on these to me. Then we have comment from anonymous attendee. We should consider the outcome of the proposed scenario. Even though the Sukuk is not registered, the securities placed will ultimately secure the interest of the Sukuk holder and ensure they receive their rights even without registration. I think this is in line with what I said and what Sheikh Said concluded. Okay, there is a question on this one by either the same anonymous attendee or another anonymous attendee. A man taken loan from a conventional bank with the pledge mortgage, its tangible asset which is building. At this stage, he wants to raise capital for issuing Sukuk. He wants the repayment of loan by using Sukuk. It's possible or not. So the point is, Sheikh, that the asset currently is pledged. The asset currently is pledged, but he wants to create a sukuk on that asset to pay that conventional. So I think it's a very good point that because we said that you cannot use sukuk for assets which are pledged for conventional for doing sukuk. But the person wants to create sukuk and actually pay that conventional. But as of now, it is pledged till the time it is not cleared. It's a good point, sir.
Point, and I'm talking now from my practice, not according to the standard. So we have faced this issue in some of the transactions. So usually there will be an undertaking to pay the liability of the customer, and according to that, the mortgage is released, and then we do the
So
purchase.
first mortgage is released. First
Yes,
mortgage
of
is
course,
released
of
based
course.
on bank guarantee, sort of
Yes,
bank
yes.
guarantee.
Sometimes they go together to the municipality, for example, and they do the release, and at the same time, in minutes, they sign the purchase agreement. Same time. So
Sir,
to
do you
avoid,
think it
so
needs
there
some
are
explanation?
solutions for this.
Do
Sorry?
you think it needs some explanation in the standard on this part?
No,
Like,
this
for
is a
example, we
very,
said he
very.
cannot do on that, and we may add, except for that, this sukuk will be eventually repaying that debt.
This is
Something
understood,
like
Brother
this.
Omar. Yani the issue is that when you execute the purchase agreement, are the assets mortgaged, pledged or not at that
At
time?
that moment, they are clear. Okay.
At that moment. So it's understood. So, but what I mentioned is a process. I don't think the standard should go to this detail.
Okay, sir. Sir, this is 11:45. I think that a prayer time in Bahrain has not yet started, but in other parts, normally the prayer time is already there. I believe in UAE and in other countries where we are having people from. So if I think in Bahrain the time will start 11:52, Brother Abdurrahman, or 11:58. Can we continue 10 more minutes? Because no, 11:52 Bahrain time will start. So can we take a break now for 20 to 25 minutes for prayers and people can stretch their legs and all that. So if we take break now from now till 12:05, sir, would it be okay?
Okay, no problem.
Okay. So all of you,
Do
thank
we
you
continue
very
for 1 hour, isn't it?
Yeah, then we complete after that. We end today at 1 p.m. Inshallah.
Inshallah.
Inshallah. So at this point, we have 11:45, roughly 12:05. Inshallah, we start again. Please, all of you are requested to continue. After that, we will end inshallah at 1 p.m. In between, we can pray and we can stretch our legs. Inshallah. See you in 20 minutes.
See you.
Assalamu alaikum, sir.
السلام ورحمة الله وبركاته.
Walaikum salam.
I think we should continue, sir. We are a couple of minutes late as compared to what time we said. So with your okay, sir. Thank you very much. We'll start again. We'll quickly see if any pending question is there in this section only. That is section 5.2. Okay, let me see. I can see a couple of general questions here. Okay. Sir, very quick question, comment I will take from this one from Brother Osama Wakil on the same discussion that we were having. He suggested to have an escrow account with regard to the example that we were discussing, that if it is prohibited to have a pledge account for that, then can we create an escrow account for that one? But I think your way of explanation is clear that first, the asset need to be released from the pledge. So either a escrow account is made for that or not, that is the modality. But the condition of the standard is that before execution, the Sukuk transaction, the pledge should be released. Am I right, sir?
Yeah.
So escrow account can be a modality part of it.
You're right.
Sheikh, there is one comment, although it's a bit general, but it's a very valid comment. And I think considering some of the market issues, you will see Brother Mufti Khwaja has another view. Can we add some clarity that some Sukuk may be Sharia compliant, though they are not fulfilling the requirements as per AAOIFI, including if these which are allowed inspection as per AAOIFI, will that may be for rating companies or Sukuk, especially in future? I think the issue is, again, we respect every single scholar who has a right to take his personal view based on his ijtihad and based on his knowledge to allow a sukuk or not to allow a sukuk. But when we talk about creating a market discipline, we need to come up a set of harmonized standards which set the best practices, because these things are in public domain. These are in regulatory and controlled activities. So from that perspective, keeping it completely open in the hand of the individual scholars would not be appropriate, and it does not undermine our respect for those scholars who individually approve these things based on their knowledge and their ijtihad. But having a system, having a market confidence requires that you need to follow the standardized set of standards. So I think, Brother Khwaja Nurulsan, your point is valid, but standard cannot say that you can be out of it and you can still be Sharia compliant. We have a couple of comments with regard to general comments, so I'll just skip them for now, and I'll move to the next section, sir. The next section is 5.3. 5.3 section goes for we have covered all the comments on 5.2. Sorry, we can move to 6.1, risks of Sukuk. This section, 6.1, do we have any comments on section 6.1, please, about risks of Sukuk? Some of the risk-related aspects we have already discussed. So let me see. So I can see some comments added. I'm sorry, sir. There is one comment that I missed out from Brother Anwar Subra, and that's about 5.2.5.2. If you allow me to just take that one. Brother Anwar Subra says a legal opinion advised a firm opinion in the form of warning that the counter deed may fire back because it can be used by court as a proof that the sale is not true but sham. The counter deed must first be cleared before recommending using it. Actually, this is a very alarming situation if it happens. So the point is, Brother Anwar is taking an argument that the court may consider a counter deed as instead of a proof of ownership, Rather, it will take the whole transaction as against the whole concept, that it is a proof that it was not a genuine sale. I'm not sure, Brother Anwar, this legal opinion that because he's saying that it is from a firm, it is advised based on a legal opinion. So we don't have any further details on that part. But Sheikh Usaid, sir, can we just make a note of it for the Sharia board? If Sharia board feels that there can be any risk like this, that it can be considered absolutely other way around, then we can, like, consider taking this one. Although I personally am not sure, and no example like this has been in my knowledge, but that is itself there. Brother Anwar has a general comment about risk of sukuk, that these are governance issues and not Sharia issues. I think the way it is written, Sheikh, Dr. Anwar, I think it covers the risks from the Sharia perspective, that what are the ownership related risks and other risks that are to be taken. So from that perspective, it is actually the requirement of the Sharia standard. And because of significance of the matters, this standard has touched upon on the governance part as well as accounting part as well a bit, not like, duplicating the whole governance standard or not duplicating the whole of the accounting standard, but it has touched upon some of the aspects already because of the significance. And at times it happens that a country adopts AAOIFI Sharia standard, but not governance and accounting. So it is considering the significance of this one, actually it was a good decision of the Sharia board to touch upon a couple of accounting and governance issues in this one. Sir, we do not have any comment on section 6.1, which is about ownership types of risk, including the ownership and title risk, the credit risk, the market risk, exchange rate risk of periodic distribution, and hedging via securities and protection by Sharia compliant means, and hedging by way of reserve accounts. These are okay, can we? I think we don't have any comment on this one, sir. On 6.1
There
to
is something, I have seen something from Omar. He's saying that, what is it? The risk is a governance issue, not a Sharia.
yeah, Brother Anwar Sobra.
Anwar, okay.
Anwar Sobra. That was the comment that I responded, that that here the risks are covered from Sharia perspective, but additionally this standards has touched upon a little bit of governance and accounting aspects as well. Sheikh, there is one comment by Brother Sohail Zubairi, which is a bit detailed and a bit more like, general, but one part of it is important. Market generally considers Sukuk as debt market instrument or debt capital market instrument, while Sukuk in fact is equity instrument. It means equity capital market instrument. So should it be somehow clarified? I think you have already answered that question, that the terminology has not been covered. Like, when we were discussing this asset light thing, or you mentioned about asset backed and versus asset based. So some are beneficial ownership. So that terminology has not been addressed, although if you understand this standard, technically it clarifies this point. I think Brother Mufti Khwaja Nurul Hassan has a point on section 6.1, and I think his point is mainly on 6.1. His point is mainly 6.1, 6.121. Sheikh, his point is that Sharia compliant securities or conventional bond, etc., up to the principal amount. So there is a view of certain scholars that you can take the conventional bonds up to the amount of capital. But AAOIFI's standard on mortgage and rahan, that does not allow it, Brother Mufti Khwaja Nurul Hassan. That standard does not allow. Sheikh, with your permission, actually, I'm just answering him directly. If you can add something. But the question is, shall we add a reference to the rahan standard here as well? Because the rahan standard actually addresses that issue, that Sharia non-compliant securities and interest-bearing securities are not acceptable security. But here we have not created a cross-reference of that standard. Would it be appropriate, because we received this comment, that can we have conventional bond till up to the principal amount? Answer in that standard is no. So shall we create cross-reference? Yes, sir?
Yeah. Cross-reference is needed here. Yeah, as you see.
Yeah, so we'll add a cross-reference, Brother Mufti Khwaja Nurul Hasan, but that is not allowed. Individual fatwas can be there, but the AAOIFI Sharia standard view is it is not allowed. On 612A3, 612A3, Brother Anwar Subra has a point here that please add reference to clause 8111A and B. I think, let me just have a look quickly, 811A.
Refer to clause 8111A and B.
111A and B.
612. I think there is the number of article is not correct. Brother Anwar, if you make sure that the number is correct. He sent the correction. 6122, 6122, A3. A3, down, brother.
Okay,
Further
down to
down.
this one. Okay, 6122A3, please add reference to 81122A3.
Yeah, the next one.
The next one, A3, this one, cumulative based. To add a reference
A3.
to
Yes.
yeah, A3, it is A3, and please add reference to clause 8111A and B.
So cross reference to 8111A, B.
That is about cumulative contract Sukuk.
Yeah, the incentive.
Yeah. He has created a cross reference to this one, A and B.
Yeah.
Types of cumulative contracts.
Okay, we take note, Brother Omar. Let us take notes.
Yeah. We just, yes. No, I just wanted to understand his comment. That is taken a note. Thank you very much, Brother Anwar. Thank you very much. Okay, so if we don't have any other comment, shall we move ahead now to next section? That is on 6.1 is done. And now we come to 6.2, securities and Sukuk. Now, securities in Sukuk 6.2, 6.1, and this section, the whole section, we are taking the comments together. So, is anybody having any comment on this one? I think again I missed one important point, Sheikh Hussaid. I think on 5.2.5. The question is, if not registered, then tax benefit, who will take the tax benefit? So for example, a tax benefit or tax incidence, both. So there is an asset, which is the underlying asset of Sukuk, and that may have a tax incidence, means there can be taxes payable on that, or there can be some tax benefit of, like, for example, the claiming the depreciation and all that. So the question is, for Brother Mufti Khwaja, I think your point is valid. In accounting side, we simply believe that the total risk and reward incidental to ownership include the taxation part as well, which means that when you say that you have the risk and reward of the asset, then that tax benefit or some things need to be passed on to you as well. This is something that completes the risk and reward part on the accounting side. Sheikh Hussain, would you like to answer this one, or just want to take a note of it, that if there is an asset which is not registered, there can be a tax expense against that, or there can be a tax advantage against that. The question is, who takes that? Is it taken by the party who legally has the title of that one, or should it be passed on to the genuine owners who don't have the registered title? The
Of course,
benefit should be, yeah.
Sheikh, any expenses related to the ownership should be on the owners of the
Exactly.
assets,
So,
which are
and
the
on the
Sukuk
other
product.
side, the
And
tax benefit, if the benefit
of
comes.
course,
So the
this
benefit
will
comes,
come.
it's the same thing.
This will come in paragraph or article 11.
Okay, sir.
We'll speak
So,
about expenses, profits, and losses on Sukuk. It will come in
okay,
the
sir.
almost end of the standard.
Okay. So irrespective of whether these are registered in the name or not registered in the name, but the point itself is clear. Brother Osama Wakil added a question to that part. Who will claim the deferred tax asset? Brother Osama Wakil, who claims the tax, who has the right on tax, will have the right on the deferred tax as well. Right or responsibility, both. So we don't receive any other comments on this section 6.2. I thought in 6.2 there will be some questions, but I think we are not receiving any more questions on 6.2. So we move to 6.3. I think 6.3 must have questions. 6.3 is something, couple of questions already came. That is undertaking to purchase the underlying assets of Sukuk. It is one of the most fundamental issues on Sukuk. I think a couple of questions related to this were already discussed. So the question is, are we having any additional questions in addition to what we already discussed about the provisions for purchase undertaking? So what is allowed, what is not allowed, and what value? These are the main questions. Any comment on that one? I can't see any comment on 6.3, although I was personally thinking there will be so many comments coming on this one in particular. I think two questions already were there with regard to purchase undertaking. One was about considering it as a party, and second was including it in the beginning. I think the main requirements are already covered here. An exercise of purchase undertaking also, I think it is covered. So let's move ahead. Okay, we have comment from Megat H. Hassan for 6.3. What would be the effect of dissolution event on the purchase undertaking? I think it's a good comment, sir. On the dissolution event on 6.3, it's a general point that if there is a dissolution event or event of default resulting in liquidation of Sukuk, what happens about the purchase undertaking? Is there anything specific in the standard on that part, sir, or generally we'll have to go back to the respective product standard?
It will be executed. Here we have just a second, Brother Omar. Yeah, if you go to
637 and 6. Yeah, 637 and 6. Yeah. Because if he refrains to perform this one, then still it will be imposed if needed in case of depending on the structure. Exactly. 636 and 6336 and 6337.
Yeah.
But if it is not possible, then it is not permitted the amount of price to be exercised. Now, this actually clarifies one part. For my understanding, I'm clarifying that it will not automatically be executed unless the originator executes it. This is the meaning of 6336 and 6337. Am I right, sir? That it needs to be exercised on that day. He will be asked to exercise it. But if he refrains for doing that, then it does not mean that automatically the price may be taken.
You remember in the Court of England on Danagas case? Decided that
Dana gas case. Exactly, Dana gas case. Yes.
Decided that the purchase undertaking is itself an undertaking, absolute undertaking to pay the amount, which is wrong from Sharia perspective. So the court said whether the purchase is executed or not, there is a liability on Dana gas to pay the exercise price, which is wrong. Therefore, the standard is clarifying this issue. The purchase undertaking itself will not create a liability to pay the exercise price. The purchase should be executed to create this liability. Otherwise, there will be no liability on the
So
originator or on the obligor.
if the purchase is not executed, then the right on the underlying asset is established, not the right on the price. Just to clarify.
You're right.
Okay, Brother Anwar has put a comment on para 7. So I think this one is clear about 6.3 that we are not having any other comments. 6.3 itself is quite detailed, and I thought we will be having a lot of discussion on this one. Now coming to 7, and I think today we will complete till 7, and section 8 onwards we'll keep for tomorrow. So let's go for the para 7. Unless if we don't get any enough comments on that one, then we can move ahead. But otherwise, I think section 7 should be our concept for today, our closing section for today. Now, for the concept of Sukuk issuance and the Sukuk issuance related requirements, which are covered in section 7, we request your comments, particularly with regard to the general rules of Sukuk issuance, etc. Brother Anwar Sobra has raised a comment on 7 to 11. So I'll jump to 7 to 11 for now. If you have any comment on points before that, please feel free. On 7 to 11, he has come. It is about it's permitted to use the debt owed by originator resulting from Sukuk as a consideration for security holder subscription to other Sukuk issued by originator if it doesn't by agreement between them. The question is, can we add the Sharia rules for the following? 1. In case Sukuk subscription is higher than requested, does the originator has the right to increase the issue value? 2. In case the subscription is less than requested, does the originator has the right to reduce the value of issue or cancel it in full? Because this relates to change in the offer acceptance of Sukuk value. Sheikh Hussain?
Technical issue, Sheikh.
So the point is we leave it to the offering. We leave it to the offering. So what they have mentioned in the offerings, sorry, for example, if they have a green shoe option to increase it, so it will be covered. So it depends on the offering document and more on the technicalities and not about Sharia. Am I right, sir?
Yeah, and there will be allocation process.
Okay.
And people will subscribe or the entities will subscribe, but then will be allocation depending on the subscription amount, whether the amount is more or less. If it is more, then the allocation will be percentage-wise will be less. If the subscription amount is less than the issuance amount, then they will need to reduce the issue size.
Now, Sheikh, I have an issue that I felt myself, and I very briefly discussed with you earlier as well, if you recall. And that issue is something that I believe is not addressed properly by the standard, and it relates to this area. That is about the bidding process for Sukuk, and particularly if Sukuk are issued in discount. The question is that if, like conventional T-bill, I go for a bidding process, and for example, if I say I am having Ijara Sukuk and I say, please bid for the rental rate. Okay, well and good, no problem. But if I go to the market and I say that it's a Ijara Sukuk, but I want you to bid for the net discounted price. Now, the problem is that net discounted price does not result in identification of the unit price, that what actually is the unit price. So for example, if I purchase a Sukuk of 100 for 92. I do not say that 92 or that 100 would be reflecting X percentage or 0.00X percentage of the total asset. So it means that at the bidding process today, I bid without identification of the exact proportion of the asset that I will own. This is just one example that the conventional bidding process of bonds, when it is tried to be translated to Islamic Sharia compliant Sukuk, it reflects a fundamental issue of bidding of money against money. So it is quite possible that going forward, the contract, and at that time the fair value of asset and other things may be determined. But what I am concerned here is the process before that. The process of bidding again, particularly in case of discounted or on premium Sukuk. So if the Sukuk is on premium or Sukuk is on discount, if I just bid on the rate that I will have this much rental rate, that is, I think, acceptable bidding. But if it comes on the bidding of the discounted Sukuk or Sukuk at premium, without identifying that I will be owning how much proportion of the physical asset, this creates a fundamental issue. Now, this practice has started in several countries, and this is unfortunately not addressed here in this standard. Again, it's not necessary if the board need to see, because it's already a long standard. This issue may be addressed somewhere later, or it may be addressed now. But this is a very fundamental issue. The whole bidding process and this general Sukuk issuance process need to be addressing this issue of issuance of discount, issuance of premium, bidding process. What are the requirements to avoid jahl at the time of the bidding process, sir?
Brother, it's a good time to propose this, explain it and present it to the Sharia board, because in the last meeting, we have discussed the discounting issue, and the board felt that no need to address it in this standard because it is still a new practice. So if it is, I think, based on your explanation, it's very important. And let us present it again to the board and explain how important is it.
Thank you very much, sir. Inshallah, I will send it in writing as well.
Inshallah.
Okay. So then we have another comment from, now we have got some comment on this one coming. Brother Khwaja Nurul Hasan is taking us back to 6336. Under the diminishing musharaka facility in some jurisdictions, purchase undertaking is earlier executed, and on the payment date throughout the tenure, the amount is debited by the bank and it will be considered as ta'ati. Implicit sale permission, and no document is executed on the date and no permission is taken. So Sheikh, it is about diminishing musharaka based on shirkatul milk, where there is a continuing payment, payment of the purchase of units, and those purchase of units happen without a separate offer and acceptance based on payment. So the promise is there and a payment is made. A separate documentation of offer and acceptance is not done, but based on the understanding of promise or undertaking that is already made, making the payment itself is considered offer and acceptance, because one party makes payment and the other party accepts it. So a separate documentation of offer and acceptance is missing. This is a question by Brother Mufti Khwaja Nurul Hasan about purchase undertaking. We are not addressing this issue, that in what situation payment can be considered a deemed offer and acceptance of payment is considered a deemed acceptance if a purchase undertaking is available.
It is addressed indirectly, Brother Omar, in 6.3.3.6.
6336.
6336, yes.
6336.
The one, yeah, this one.
Yeah.
You see?
However, if refrain for performing purchase reference to perform undertaking returns to the underlying with owes compensation. However, if it refrained for performing the purchase undertaking did not return the underlying asset to the certificate holder. No, sir, it's other way around. Making payment. Like for example, the originator makes payment but no, like he's talking about gradual transfer in diminishing musharaka. So for example, there is a quarterly payment or a half-yearly payment. Half-yearly payment is made, sir, to the Sukuk holder, by the originator. Now, there is no offer and acceptance documentation done.
Sorry, Brother Omar, if you go
yes,
to the next one,
yes,
633.7.
Okay.
Okay, a matter beyond the ability of originator, then it's permitted that the amount of the price at which price undertaking is exercised to be recognized that owned كذا nor any compensation كذا كذا cannot be morally
No, sir,
by
this is the
and the
situation when payment
originator
is not done.
continues to retain possession of the underlying assets of Sukuk, then this is deemed after the lapse of a specified period as an acceptance in action by the originator to purchase those assets at a price stipulated in the purchase agreement. So the concept is there, but the particular example you mentioned is not there, but the concept is acceptable.
So that particular example can be added here, or it can be added in the section where we
We
have
can
discussed this
we
diminishing
can
musharaka
yeah
situation. Just to maybe a couple of lines we can
we
add
can propose
that.
that
Yeah, we can propose that to the board. Thank you again, Brother Mufti Khwajarul Hasan. Thank you for that. We have comment again. I will drop a couple of comments, but I think underwriting okay, Brother Osama Wakil has mentioned about the shortfall. So underwriter will subscribe the rest. Yes, this is normally the regulatory and good practice, which is already there. Now we have question from Brother Zuhair Abdul Razak. Point 6.26 allows a third party other than the originator or its representative to bear the compensation for the loss of Sukuk capital or decrease in profit, or to purchase the underlying asset for a specified amount. He's talking about 6.2.6. Am I right? Six point two. I think reference is not correct, but the point is he's referring to 6.2. This is about third party other than the originator. I think we have a 50% condition here as well, here or in the another clause. I think we have that one. So the question is here, what makes a third party bear the loss of asset value to difference in profit? I feel this is some sort of manipulation in this point.
Yeah, this is very valid question, but the government may do that. The government may do that.
Okay, Sheikh, if the question, I'll come to that question about the other clause that has mentioned 50% here. Not in this clause, but other clause in the relevant section, it mentions about that third party should not be holding more than 50%, or this party should not be holding more than 50% of the party. The question is, 50%, Sheikh, makes it huge. Don't you think that it should be 33% or less?
What?
For the ownership rule. The ownership rule for the third party here is 50%. My point is, Asulus Kasir, that analogy.
Less than 50%, as I remember.
It
Less
says
than 50
not more than
or
50%.
50.
I think it says
Not
not
more
more than
than
50%.
Okay. But
Yeah.
but this is in one of the previous standards, not in this standard.
I think this standard also, maybe it refers to the same thing. But can we put this thing again to the Sharia board now, based on this point, that to avoid that manipulation part, should it be reconsidered by the board to bring it down from 50% to 33% at least?
I personally support that.
Okay.
Because
So
I believe that any ownership and whatever the percentage should be, we cannot consider that party as a third party.
Yeah. So just let me tell. I would suggest two different suggestions.
Brother Omar,
Yes.
and there are scholars believe that the third party guarantee is not practical. But as I recall, it has been applied in Jordan by the government.
This is good, sir.
support
If
the
government
issuance of the
government supports this thing, that is very good, sir. Just let me put one question here, that we have two analogies here. One analogy is 50% is too much, sir. It should not be allowed at all. But based on Brother Zuhair's comment, I would add my comment. There are two analogies. One is in other areas where we use the analogy of Asulus Kathir. So it should not be more than 33%. Then there is another term, sir, that we use in accounting. In accounting, the term is used, we call significant influence. So my point is, if I exercise significant influence on the counterparty, and then independence is gone. Now, significant influence, normal criteria is 20%. And other, like, having common board of directors members, having, like, other contracts in a situation that I can influence their decision. So the point is that I would suggest that we make our suggestion based on this thing, that significant influence as 20% and having common directors and all that, which means that they are taking the same decision. It means that it becomes like, the own guarantee, or at least say, like, either at least at max 33%, but normally it should be less than 20%. So that in common, significant influence is not exercised with regard to that.
All right, brother.
So, Brother Shakir, if you can add this point from Brother Zohair and my additional comment to be passed on to the Sharia board, inshallah.
Yes, noted.
Sir, we have again a comment from Brother Sama Wakil. Underwriter gets the unscrapped portion at a discounted floor price beforehand, decided before public subscription. Sheikh, I just mentioned this one because if underwriter gets on a discount, then again the issue of jahl may arise in some situations. So that issue need to be addressed additionally. Brother Shakir, if you can note this one also, that if underwriter takes on a discount, then the issue of proportionate ownership and those things might still remain undecided. So that is additionally a point that we need to consider on the discount side. Then we have, sir, this Brother Anwar's comment on 7211 and 8112C7, Sukuk issued to settle debt owed by the originator. So let me come to 7211.
7211.
It is permitted to use the debt owed by the resulting from Sukuk as a consideration for the Sukuk holder's subscription to other Sukuk issued by the originator if it is done by the agreement between the Sukuk holder and the originator at the time of subscribing the new Sukuk, provided that new Sukuk not based on partnership, investment agency or salam, and that the underlying asset of the new Sukuk are acceptable to be exchanged for debt without being bound by the provision of debt disposal. Brother Anwar's comment is, what if debt is not from Sukuk but from outstanding debts or accounts payable to creditors, suppliers or contractors? This is renewal of or revolving of debt qalbuddain. In addition, using Sukuk proceeds to settle debts defeats the purpose of Sukuk to provide liquidity to invest in income generating assets. To settle debts mean no asset. Therefore, what is the source of periodic payment?
So therefore, for the issue of qalbuddain, revolving of the debt, there is a cross reference to the standard 59.
Thank you very much. And just to clarify to Brother Anwar, if you see, this is still a condition that partnership, investment agency or salam are not there. Because for partnership, debt cannot be capital. That is written in other standards. So technically, the issue that you are addressing is addressed because then it means there will be some other asset to create that thing. So if these exclusions are there, other asset must be there. Again, Brother Muhammad Abdul Razak, under 6336, it is not clear. It is not clear to me how Ijara can continue if the originator decides to retain the asset after refraining from exercising the purchase undertaking. The originator won't no longer be lessee as if he would keep the assets with him. So it's a very good point, Sheikh, that, for example, the situation is that lessee is still keeping the asset with him. So because if it is lease, then rent may continue till the time either you settle or either you exercise the purchase undertaking or the lease period may extend. So the question is, Sheikh, based on what Brother Abdul Razak has mentioned, can lease extend automatically? If the lessee does not return the asset, then lease may continue as it is. Am I right? That is the meaning of this one?
Yeah. And automatically, if it is mentioned in the agreement that if end of the term of the ijara, the parties have not executed, for example, the purchase undertaking, then the ijara will continue for a similar period according to the same terms and conditions. Then it is fine. But here, what is the assumption? The assumption is that the ijara term is not finished yet, and we want to execute the purchase undertaking, and the purchase undertaking has not been executed, and the originator decided to retain the assets and not to return the assets to the sukuk holders. Then in this case, will not be the ijara will not be considered terminated and will continue until the end of the term of the ijara mentioned in the agreement.
Sheikh, I'm aware that Ijara standard is also subject to revision, and I think the near final version of the exposure draft is ready, which is subject to editing right now. So the question is, has that new standard addressed this issue about continuity of lease in case of, for example, I'm in a house and the lease rental is for lease agreement is for 2 years. Now, after completion of 2 years, I have not vacated the house, I have not returned it, and I say, okay, agreement closed, so I don't pay the rent. So the question is, if that is clear on the lease standard about the continuity in case either it is not returned back, asset is not returned back, and purchase undertaking is not there. So in order to safeguard the interest of the bank and the investors and the lessors, I think something like this should be there based on what he has mentioned.
I don't think it is there, but it's a good suggestion because this is something needed in the market. But as I remember, in some laws, like in the UAE, for example, even if you don't mention this in the agreement, it will be applied. No need to mention it in the ijara agreement.
In-house laws, normally, sir, it is there. In-house laws, normally the countries where house rental laws are there, it is automatically there. But with regard to other leases, it might or might not be there. So it would be good if Sharia standard considers it.
You are right. Addressing this in the Sharia, in the ijara standard is inshallah, is required.
Thank you, sir. Now we have again comment from our brother Sadaqat on 7 to 11. Let me just go back to 7 to 11. His comment is that it is permitted to use the debt, otherwise it's required to comply with requirement with this. At least some major compliance areas or Sharia rules should be listed here besides referring to above standards. Means I think that he wants to clarify that what is the Sharia requirement. Brother Sadaqat, the main Sharia requirement is already there, that provided that new sukuk should not be based on these partnerships. So I think that part is already clear. The most important compliance issue is addressed. But still, if you want to address the more specific issue, please be more specific in your comment that what need to be written here. We have comment again from a brother Usama Wakil. Underwriter get the unsubscribed portion at discounted. Okay, we discussed this one. Okay, brother Anwar has a comment again. Your answer does not answer my concern. The clause referred to debts specifically with no assets. You are assuming presence of assets. Sheikh, I think we take brother Anwar's comment to the Sharia board and see how it, the Sharia board thinks about it and what need to be amended here in the view of Sharia board.
That's fine.
Thank you very much, brother Anwar, for your you always have some very good comments. So, sir, I think with the with 7.3 base prospectus, some points. Okay, we have comment from brother Professor Abdul Salam Unagan. My concern is that standard use sukuks instead of sukuk because the word is plural in Arabic. I think the plural of sukuk should itself be sukuk. I think that is correct. But this is something that we've passed on to the Sharia committee for translation committee, Sharia Standards Translation Committee, for consistent decision on that part. Thank you very much, Professor Abdul Salam. Then we have,
call it in Arabic jam'ul jam'.
Jam'ul jam'. So then we have, sir, this, but that can be an argument because if you have different sukuk, 5 different sukuk, when you collectively refer to them, do you still apply only the singular term sukuk, or you can apply sukuks? Let Sharia Translation Committee make a decision. Okay.
Just want to raise one point. It was
yes, sir.
used only one place when different types of sukuk were mentioned. So it was a hybrid structure. That's why we said sukuks, because that was
Okay.
referring to mudaraba and murabaha and many sukuk. That's why.
So maybe, Dr. Yusuf, in this particular place, you can put S in brackets.
In brackets, right?
It's a good idea, sir. Thank you very much. Okay, so then we have Brother Muhammad Imran's comment is very quick. Least will be continue at least at Ujratul Misl. Mufti Khaja Nurul Hasan, then the plural will asakik will be asakik plural of plural. You have suggested it should be asakik. Actually, in AOIFI's writing style, we make our term, we romanize a term. Once it is romanized, it becomes like an English term. And then we apply English rules on that. That is what normally we do in writing style. Okay. Okay, the brother Abdul Razak has again a very good question, Muhammad Abdul Razak. Under 7327, should the originator full disclose the disclosure of the underlying asset, or some of them are reluctant to share such detail for confidentiality? Who should perform the due diligence on behalf of the certificate holders? It's actually a good point, and actually this base prospectus and some other things are actually governance issues. Some of them are touched upon in this standard, some are touched upon in the AOIFI's governance standard, but this question itself is important, but I think it would not be subject of Sharia standard. It would be subject of governance standard. We can pass on that comment to the governance team. I think Sharia standard may not go in that much detail. Okay, now we have another comment by Brother Ashadur Rahman. Okay, I think we are going for more detail about this one. Okay, do we have any other comments now? Because now we are ending today's allocated time, and inshallah we'll have to start tomorrow again. So do we have any other comments on section 7.3 so that we can consider section 7.3 closed today and we start afterwards tomorrow, inshallah? Brother Mufti Khwaja Nurul Hasan has again mentioned something about 6336. What point is this, brother? It is just a reference. I can't see your complete point.
This is about the ijara. The ijara will continue.
Okay, he's talking about ijara to continue. No,
Yani
now the point I can see. Now at the point I can see. Can we add some clarity that some sukuk may be Sharia compliant? Okay, no, I think this is also done.
Umar, the wording here in Arabic, we say تبقى الإجارة أو الوكالة تبقى قائمة. Yani it means that it has not been terminated or not finished the term. So in English, remain valid. So it is not an automatic renewal of the ijara.
It continues.
Is still, it will continue.
Valid. It's valid. Yeah, it's valid. Okay, 73214. This is a comment by again Brother Anwar. 73214. And that point is very specific about a term that we have used here. It says that acceptable as per Sharia. That what is the meaning of accepted Sharia nature of sukuk? Accept Sharia nature of sukuk. Stating that all the parties,
This is currently used in the sukuk documentation.
The purpose, I believe, is that they accept this nature and they don't resolve to the they do not go to the conventional legal terms for that. Rather, they accept the terms defined in the contract.
Yani this clause proposed by the by lawyers after the Danagaz case. So they don't want, for example, after 10 years or 5 years, whatever, the originator or any party will, they don't want anyone to go and claim that the sukuk are not Sharia compliant. So when we issue the sukuk, you have to recognize that you accept the Sharia
as a party to the contract. As a party to the contract, you are agreeing that you will agree the terms defined and the Sharia nature and characteristics defined in this contract. And you will not go to the conventional definitions of that. So all the parties agree to that part. Brother Abdul Razak has mentioned that he has more comments on section 6 and 7. We'll share them tomorrow. Brother Abdul Razak, you are more than welcome to share them tomorrow. Inshallah, when we start, inshallah, we can take any remaining comments on 6 and 7 or any other section that we have, because that was the purpose of keeping 2 days, so that we can, have maximum comments. We understood that it's a long standard and it could not be done. Brother Imtiaz Abbas Hussain, couple of you, one of your questions was a bit general that I could not take here. We'll see whether we can take tomorrow. And I think there are some smaller comments here, Sheikh. Point on lease continuity is already partially addressed in current Ijara standard, is only based on contractual agreement. But the point is, what happens if the contractual agreement is not there? So I think we need to clarify that part.
Brother Umar, any one of our of the participants, brothers or sisters, can send the question or the comment or in writing. And in writing will be much better. Yeah, will be much better.
Exactly. So if any one of you feel your comment is not addressed properly, because we had, mashallah, 127 plus 26, 150 plus comments, and we had some discussion on some important subjects. So actually, we might have missed out something important. So please feel free to send them in writing. More significant comments, particularly on section 6 and 7, as some people have mentioned, we can take them tomorrow morning as well. Brother Abdurrahman, do we have any other announcement except for that tomorrow, inshallah, we'll continue same time, 9 a.m. Bahrain time. And if you want to make any other announcement, otherwise we can request Sheikh Hussain to have dua and close today's meeting.
No, just I want to emphasize what Sheikh Hussain mentioned, that we are welcoming any comments through this email which we just put it, sharia@aoifi.com. So if any comment we missed, you didn't answer on it, or even for tomorrow, so it will be better. It will be even easy for us to take it to Sharia board.
Inshallah. Sheikh Hussain, if we can, if you can kindly conclude, sir.
We'll conclude with thanking all participants with their valuable comments and feedback, questions. Inshallah, we'll continue tomorrow. With this, I will say, Subhanak Allahumma bihamdik, nashhadu an la ilaha illa ant, nastaghfiruka wa natubu ilayk. Thank you all. Assalamu alaikum.
Thank you, everybody. Thank you, sir. Assalamu alaikum.
Wa alaikum assalam.